No problem. No problem. Okay. I'm interested in starting us off because I don't want to lose any time because I know we're going to hear such interesting things. We're going to want to have all the time we need. So good afternoon. I'm Christine Haight-Farley, and I'm a law professor here as well as a faculty director of our program on information justice and intellectual property law. And I'm delighted to welcome you here today on behalf of the law school and the School of Communications to our program on ICANN and the new GTLDs. So I'm delighted that you're here. I'll begin by saying that I'll explain why we're here. So very recently, a few things occurred to me. The first is that people who are very knowledgeable about IP law or tech policy or even both somehow, and we can maybe talk a little bit in this discussion about why this is, but somehow aren't always closely following these developments. And so I think that's interesting because these developments are so very interesting and relate so closely to the things that these experts pay attention to. It also occurred to me that many of the movers and shakers in this area are right here in DC. And finally, it occurred to me that I can just have a conference on a topic I like whenever I like. So I decided, combining those three ideas, let's get together and do this. So I want to begin by thanking everybody who indulged me on fairly short notice to make this happen. First of all, that includes our wonderful speakers. I'm glad that you're here. I know that you're busy, and I'm glad that you can devote the time. And although many of the experts are here in DC, some of our speakers had to travel from California and other places, and one is still traveling from Canada and will be here with us very shortly, I hope. I want to thank my colleagues. I'm really glad for the partnership with the School of Communications. And I want to thank the staff who, in the end, actually made this happen. So that was really wonderful. And I want to thank you for showing up. I can see that this is a very knowledgeable audience, so we're definitely going to leave time for questions so that we can hear from members of the audience. So I have two objectives this afternoon. The first is I want to demonstrate that people who do not agree on all topics can have a very productive discussion. And what the audience may not know, but which every speaker on this program knows, is that I've identified people who sit at all different points on the spectrum in terms of their viewpoint on these topics, so I think that will make for a really interesting conversation. And we hope it will be a conversation. The second objective is, of course, to demonstrate for the world, and hello, internet audience, to demonstrate for the world that this really is a space that you should watch. I mean, if you just think about it, ICANN has recently developed all of this, or not developed, has made available all of this new real estate in a new jurisdiction with new policies in which there will be new issues that have never been dealt with before. So who could turn away from that, really? And so I'm grateful to all of you who will make these things possible. Now some really important information. Bathrooms are out the door and to the left. And turn off your ringers, please. But don't turn off your cell phones. You should be live tweeting this event. And how about the hashtag AUNewGTLDs? Just saying. Okay, so now on to our first panel, which conveniently I'm moderating. So the first panel will focus on new rights protection mechanisms that were developed especially for trademark owners in these new GTLDs. And the very short background, but we'll get into it more, is that ICANN has developed some new mechanisms that were specifically designed to appease trademark owners who are quite concerned about new GTLDs. And there are a number of them, and we don't have enough time to talk about all of them. So for instance, one of the new mechanisms is the Uniform Rapid Suspension System, otherwise known as URS, which is a quicker and cheaper dispute resolution procedure. There were pre-delegation and post-delegation dispute procedures. And in addition, there were some private protections that have been offered in these new GTLDs. And just to give us one example, the registry Donuts has developed a blocking mechanism that allows trademark owners to, for a fee, block their trademarks across all of Donuts' 240 top-level domains. We, in this panel, are going to focus on one mechanism and some of the services that come along with that mechanism, which is the Trademark Clearinghouse, otherwise known as the TMCH. And so you've already heard me mention two acronyms. This is a community who speaks in their own special language, which involves reducing every single phrase to an acronym that can be reduced. So it makes it a little bit hard to follow along. So what we'll do on this panel is we'll rip around the panel a couple of times. I'm going to ask questions of individual speakers, and then I'm going to ask questions for the group, for everyone to contribute to. And I'm going to be sure to leave at least 15 minutes for the end to hear from the rest of you. So get your questions ready. Okay. The other thing I wanted to say is I hope that you picked up at the registration table a document which gives the biographies of all the speakers. I'm delighted by the speakers who have been willing to participate in this event. We have an ICANN founder, we have an ICANN vice president, we have 2 ICANN board members, we have renowned academics, we have fearsome NGO advocates, and we have lawyers and industry leaders who are working in the front lines in this space every day. And the people that we've assembled here to speak today are really the people who are, even as we speak, shaping these policy areas. So it's really a great benefit to us that we get to hear from them. So I won't spend our discussion time in introducing the speakers. And just as I ask each of you to speak, I'll just say a few words about who you are. So I'm going to begin at the very end with Mary Wong, who is Vice President for Strategic Community Operations, Planning, and Engagement at ICANN. And Mary, the question I would like you to address is, what is the TCMH? The TMCH, sorry. And if you could say something about who administers it, how it works, what it does, that would be great. And I'm going to fix this screen while you get started.
Sure, and thank you, Christine. Hi, everybody, and hello, Internet audience. I'm Mary Wong, and I currently work for ICANN, the Internet Corporation for Assigned Names and Numbers, but it's a pleasure to be here because before that, I was an IP law professor, and I see a lot of familiar names, friends, and faces in the room, so this is really exciting for me, in case you can't tell. But in my role here today, and I think Christine has given us just a few minutes to cover essentially 10 years of Internet history at ICANN. So I thought that what I should do is probably just focus on a few points that may be familiar to a number of people in the audience here who participate at ICANN or who have been to an ICANN meeting, but may not be as familiar to those of you who may have read about ICANN or followed along now and then, which I think makes a lot of what we're doing at ICANN for policy making really interesting and unique. But I will start with answering Christine's question on what is the Trademark Clearinghouse. And it's one of those things, if you actually just take a look at the name, Clearinghouse, it's kind of obvious what it is. But the one thing I do want to say about the Trademark Clearinghouse, or rather, let's make it 2. First is, as Christine was saying, it is one of the mechanisms that was developed, and I want to say at ICANN, not by ICANN necessarily, for the latest round of expansion of generic top-level domains. And so let me explain what I mean by at ICANN rather than by ICANN. We're a rather unique organization in that while I am a staff member at ICANN, and there's a couple of board members whom you'll meet later on, ICANN can be described in terms of policy making as a worldwide community. And so we're always talking about people that participate in the ICANN policy process. They include governments, they include businesses, they include IP lawyers, they include civil society, academics, and individuals. So when you talk about an ICANN policy, it's really not me and my colleagues sitting down in a corner writing something out, getting it out for community input, and then implementing it. A lot of times we actually think it would be easier that way, and it would certainly be faster that way. But the reason why I think this background is important is that all ICANN policies, and certainly the mechanisms that we're talking about today, were developed and agreed upon by a wide variety of interests that talked about it and included subject matter experts and came up with the system that we know today as the whole slew of rights protection mechanisms for trademark owners. So that's point number one that I think is really, really important to remember. And I'll try and end by talking about why that's really important for a different reason. But the second point I wanted to make, and again answering the question, Trademark Clearinghouse as a clearinghouse, strictly speaking, is not a rights protection mechanism as such. You'll hear from others on the panel about the Sunrise registrations, as well as the Trademark Claims Notification Service. Those are rights protection mechanisms. I'll leave them to explain what they do, but they exist in the sense that the Trademark Clearinghouse is the repository that supports those rights protection mechanisms, in that trademark owners would submit marks into the Trademark Clearinghouse. Those marks, rather their existence in a national register somewhere, for example, or because they're protected by a treaty, either international or regional, that would be validated by the operator of the Trademark Clearinghouse, which currently is Deloitte. And so there is a submission function, a validation function, and then what you end up with is a global repository that then supports the Sunrise and Claims services. And I will end and send it back to you by noting a couple of things on this slide. Besides the numbers, which are really, really interesting, if you think about the fact that over 80% of the marks submitted are validated, if you think about the fact that there's marks from well over 100 jurisdictions and several tens of thousands of them that have been submitted into the clearinghouse since it was first established, I think it must have been 5 or 6 years ago. But the thing that I did want to end with is all the stuff that's highlighted in blue. Remember that I said it's a clearinghouse with a validation function, and it serves as a repository to support rights protection mechanisms. That's important. But what's also important is the scope of the clearinghouse. And we have 3 categories of marks that can be submitted. Those would include marks that are protected by a national registration, and there's no distinction across countries. Right? As long as you have a trademark registration somewhere, you can submit it for validation by Deloitte. The second category is marks that have been validated by a court of law. So any kind of national proceeding that validates that you have a trademark. For this audience, I think the most obvious example would be common law unregistered marks. And the third and final category of marks that can be submitted into the Trademark Clearinghouse is marks that are protected by a statute or a treaty that is in existence at the time the mark is submitted for validation. And it is through this mechanism, at the one right at the end, and we may have time to discuss this, that certain types of marks, and I use that word quite broadly, that in some countries would not be protected as trademarks per se, could still be submitted to and validated by the clearinghouse. And an obvious example of this would be what we call GIs, or geographical indications. They are protected in some countries, and they are protected to some extent by some treaties. So that was a quick tour through the Trademark Clearinghouse, and I'll hand it back to you, Christine.
Okay. Thank you, and thank you for trying to be concise, Mary. I appreciate it. Okay, so next I'm going to pass it on to Brian King, who is the Director of Internet Policy and Industry Affairs at MarkMonitor. And the question I'd like you to address is, what did trademark owners want from this mechanism which facilitates other rights mechanisms, the Trademark Clearinghouse?
Sure. Thank you, Christine. So I would like for the law students in the audience and maybe watching online today to put yourself in my position, my fake make-believe position. I am an in-house trademark lawyer at a company, Delta Airlines, for example. I've just started. I finished 4 or 5 years in big law. I moved in-house, and I'm now responsible for helping my client protect their brands online and offline. And so I have some obligations. I need to monitor for infringement. We need to monitor global trademark registries around the world. Federal, the USPTO is one, multiplied by a couple hundred countries on Earth. We need to monitor all those. We need to monitor websites, internet. We might do Google searches. Maybe if I'm lucky, I might have a paralegal to help me do that. And we're also responsible for the domain name portfolio. Now we have between 5,000 and 10,000 domain names in our domain name portfolio, and those are a lot of .com domain names, but a lot of country code domain names too. We do business in Canada, so we have .ca domain names too. We do business in Mexico, we have .mx domain names too. So we have a lot of domain names, and it's a full-time job for us to monitor what's going on and see if anybody else is registering domain names that look like ours but are a little too similar and are therefore infringing. And so I pay for a service to help me do that. I hire a great company like MarkMonitor, for example, to help me do that and to provide me reports if anybody's infringing. It takes a lot of time, it's expensive, and it's hard, especially with the online stuff because it's technical and it's tough to find out who's really behind these domain names. They can hide behind privacy protection and the who is register. And I find out through outside counsel that ICANN is kicking off this new crazy concept of multiplying the 22 existing gTLDs like .com, .net, and they're just going to open it up that anybody can get their own. Now, it sounds to me like anybody could apply for .air, .airlines, .fly, .flight, concepts that might have First Amendment issues, .sucks. There's already .xxx for adult content. They might apply for .porn, .sex, .adult, concepts that we don't want our brand associated with, but we nevertheless need to protect our brand in. So we may need to register domain names just to prevent other people from having those domain names in these new TLDs. So I'm scared. I don't have a lot of budget. I don't want to ask for more budget because there's so many unknowns still. And the Trademark Clearinghouse offers me a couple assurances that make me sleep a little bit better at night. So some of those are the Sunrise registration benefit in that when these new TLDs open, so when whoever in the world applied for .fly or .air, that doesn't have to be in our industry or know anything about us, but when they kick this thing off, I at least have the option that I can go first and protect our rights there by registering. So I like the Sunrise registration mechanism. I also like that the Trademark Clearinghouse gives me a notification service. Like I said, I already pay for a monitoring service. I don't know if that's going to cover these new TLDs, right? It's expensive enough and it takes me enough time to go through all the results that I'm getting in just .com, net, org, biz, info, and museum, and some others. So what's going to happen when .fly comes out? I don't know. So I like that I get an ongoing notification service from the Trademark Clearinghouse when these domain names are going to be registered by other folks.
Great, thank you. Yeah, I think I'm okay. So our next speaker is en route. Poor thing. So we hope that he'll come and be a part of our discussion. But in the meantime, I've asked Kathy Kleiman, who is currently a fellow at Princeton and here at American University at the School of Communications. Thank you, Kathy, for stepping in and to tell us about something that Brian just mentioned, which is the Sunrise period. If you could explain what it is and how it works.
I'd be happy to. Thanks, Christine. So I am not Michael Karanikolas, and hopefully he'll be coming in from Toronto soon where he got delayed because of weather. I am, however, co-chair of the working group that's developing the policy on this. So I'll spend a second on that, which is the Review of All Rights Protection Mechanisms Policy Development Process Working Group. And you can call it the RPM PDPWG if you're an ICANN insider. I'd like Phil Corwin to wave. Phil Corwin from VeriSign is in the audience. He is our co-chair, along with Brian Beckham, who's in Geneva right now, I assume, because he's with the World Intellectual Property Organization. So the three of us have been working for 3 years with 150 members, 100 observers, but really a core of about 50 or 60 people, including some in this room, working very hard to review these mechanisms that were created before the 2012 rounds of new GTLDs, when we were, the first real round where we opened this up for applications. And now we're about to do another round, and we're going to talk about that a lot in the second panel. But what should the rules be? And this working group is looking at one small part of that, which is the rights protection mechanisms. So we will be issuing an initial report, including on the Trademark Clearinghouse. So this is policy in real time. You're hearing what we're talking about, what we're debating, and what we will be debating in 2 weeks in Kobe, Japan. But you're hearing it here in DC, so we really appreciate the opportunity to be here and talking about the discussion, which includes some free speech issues as well as intellectual property issues. So very relevant, very timely. So the quick answer to what is the sunrise period is it's one of the rights protection mechanisms, as Mary said, that uses the Trademark Clearinghouse. So we expected about 500 new applications for new top-level domains. We got close to 2,000. We actually wound up delegating over 1,300 new top-level domains. There are a few more in progress, but 1,300 is kind of probably where we're going to stay for this first round. Again, applications in 2012. So what happens when the new top-level domain is opening up? It turns out we created the sunrise period, which is 30 days, and some registries expanded it to 60 days, where if you're a trademark owner registered in the Trademark Clearinghouse, you have a right of first registration. And during those 30 to 60 days, and the Trademark Clearinghouse will send you notices, but it's a good idea to keep an eye on the Trademark Clearinghouse too, and find out when the sunrise starts, and you have that right of first registration. There are ways to prove that you're registered in the Trademark Clearinghouse. And you can pick and choose which new top-level domains are most logical for you. Is it .shop or shopping or media? But the idea is that you pick and choose. And in fact, I was at the International Trademark Association meeting just before the round opened. And I listened to some of the advice being given to this very, very large panel, at least 500 or 600 people there. And they said, it's not like today where you can have .com, .org, .net, referring to the old days. You will have to pick and choose what's relevant to your brand. And the balance here is that if you are Delta, you're going to be Delta Airlines, but there's also Delta Faucets, there's also Delta Fraternity, there's also Delta Educational Group because it's a math term, and it leaves room. The whole idea of the new GTLDs, we'll talk about this more in panel 2, is to create more space, to break the artificial scarcity of .com, .org, .net, and let everyone find the appropriate top-level domains. And the sunrise period is part of the moderation of that. It's an exact match. No variations, and it's an exact match to your term in the Trademark Clearinghouse, and then you can have that right of first registration.
Great.
Thanks.
Good, thank you. Okay, so now I want to turn to Griffin Barnett, who is a lawyer at Winterfeld IP Group, and who is also a graduate of our law school, so I'm delighted that you're here. And so the question for you is, what purpose does the TMCH serve for trademark owners? Brian talked a little bit about some of the anticipation and some of the desires, and so I'm asking you to reflect a little bit at this point in time.
Yeah, thanks. This is Griffin here for our online and in-person viewers. So yeah, I mean, it's a good question. Brian touched on a number of things that I think are important, but I want to go maybe a little bit higher level than what Brian mentioned, because I think it's always important to keep in mind from sort of a brand owner perspective, and more generally, that these mechanisms, yes, they're intended to facilitate trademark protection, but again, it's always important to keep in mind the function of trademarks, which is to protect consumers, protect internet users, et cetera, from the results of infringement, cyber squatting, fraud, and other things like that. So I think that's important to keep in mind in terms of sort of, what's the importance, not only to brand owners, but to the internet user community generally. So I'll start by saying that. And then in terms of sort of the actual kind of benefits to the brand community, I mean, I think, operationally, I think the Trademark Clearinghouse has generally worked well. Obviously Mary touched on the sort of validation process that takes place. There were some early issues with, the interface and things like that, but I think over the course of the number of years that the Trademark Clearinghouse has been operating now, a lot of those have been ironed out at sort of the operational level in terms of, working with Deloitte, who's actually implemented the Trademark Clearinghouse. to make sure that the validation process is going well and that, they're liaising as appropriate with people who are brand owners trying to record their marks in the clearinghouse. I remember some of the earlier days of when the clearinghouse first launched, and we were working with our clients to record marks in the clearinghouse. There were issues where we would get responses back from agents of Deloitte being like, this is invalid, and it would leave very little additional detail as to what the actual issue was. But they've gotten a lot better in terms of having educational resources and FAQs and things of that nature to actually help the customers of the TMSH brand, the brand owner community, kind of work through that process. So that's one thing that I would mention in terms of, there were some implementation kind of operational type issues, but a lot of those have kind of been worked out in the intervening years since it first launched. And again, the underlying purpose of all this is, to facilitate kind of the self-policing, self-enforcement task, as Brian kind of touched on, that brand owners have under our system of law, right? It's the obligation of the trademark owner to protect and enforce their rights against unauthorized third-party uses, and these mechanisms are intended to help facilitate that, again, in the context of this massive DNS expansion that took place. And again, ultimately, again, to facilitate the underlying consumer protection purpose of, if I have a Sunrise registration for my brand, then it can't go to a third party that might use it for a phishing scheme, et cetera, et cetera. And similarly, one thing that I did want to mention that I don't think Brian touched on was there are two aspects to the trademark claim service. One is a notice to the brand owner who's recorded the mark in the clearinghouse if a domain name matching that mark is registered by a third party. But during the course of the registration process, at least for the first 90 days of a new GTLD launch, a prospective registrant who attempts to register a domain name that matches a mark that's in the clearinghouse will actually receive a trademark claims notice before the registration process is complete. That sets out what the mark is, who owns it, in which jurisdictions, in connection with which goods and services, and some other details about the trademark. And it's to just notify them that there are these rights out there, and that if they continue to register the domain name, there may be consequences associated with that in terms of, from sort of an enforcement or trademark protection angle. So they're aware of that, and they can then hopefully make an informed decision about, whether they're going to be using this for a potential good faith purpose, or otherwise, if they might be deterred from making that registration based on now having the knowledge and notice that there are these rights out there. And again, I think that kind of deterrent purpose is also important to keep in mind when we think about the benefits of these mechanisms to the brand owner community, and again, keeping in mind the underlying kind of consumer protection purpose. Yeah, I think I'll stop there for now.
And I guess I'm so used to calling on Griffin that I forgot to go to Rebecca next. So Rebecca, you're going to tell us about just what Griffin was talking about, which is the trademark claims period. But before I get to that, I just wanted to ask maybe Brian and Griffin and even Mary a question. So Mary has here on the slide the number of trademark records submitted. And I wondered if you could, if you have any views about that number. Is that the number you would have expected to see at this point in time? Is that, what do you make of that? And do you have any information about who is represented in that number? Where are these registrations coming from? We're hearing a lot about lots of Chinese trademark registrations in the United States. Are these Chinese trademark registrations? Are these US? Are they major corporations? What is it? Do you have any information, and what do you think of just the quantity of trademark owners who are taking advantage of this mechanism? Any of you, if you have any ideas?
I'm happy to take
Yeah.
the first stab. Yeah, no, it's a good question. I think there's a report that Deloitte put out that summarizes a lot of the statistics in great detail, I think covering like 2013 to 2017 or something like that. But I believe the breakdown shows that a lot of the registrations, or I prefer to refer to these as trademark records or recordals as opposed to registrations, because there's that distinction between the underlying registration of the trademark. So in terms of who's actually recording trademarks in the clearinghouse, I believe the bulk of them come from the United States, from Europe, from Western jurisdictions. I think there are a number of Asian jurisdictions represented as well, but the vast majority of them, I believe, are from the United States and Europe. You know, unsurprisingly, I think a lot of large corporations that own a lot of trademarks tend to be the ones recording a number of their marks in the clearinghouse. But that said, I do know that we represent a number of smaller and medium-sized businesses who own maybe just 1 or 2 trademarks or a handful, and you know, who we've also worked with to enter their marks in the clearinghouse to reap the same exact benefits as a large company might gain. And in fact, a lot of the benefits I think are actually kind of are better for small and medium-sized businesses because they don't necessarily have the resources, as Brian alluded to earlier, to kind of take advantage of a number of the kind of other marketplace services that are out there that can potentially perform similar functions.
Yeah, Mary.
So just to add to that, ICANN doesn't, as an organization, really doesn't have a view or expectation of the numbers, but as what Griffin was saying, it is quite a widespread across various countries, but perhaps unsurprisingly, at least for the first initial few years, you are seeing the bulk of submissions and records in the clearinghouse from Western countries. There are the numbers in the Deloitte report. We haven't broken them down, but it wouldn't surprise me if you're seeing submissions and recordals go up from other countries. This is partly also because of an increasing awareness of the existence of these kinds of protections. But I think I wanted to emphasize one particular point, which is really that when you have a repository like this that is really open globally, like I said, as long as you've got a nationally or regionally registered trademark, or you've got a common law trademark that's been recognized by a court, if you know about it, you are eligible to submit your mark for validation. But whether or not a trademark owner chooses to do that, it's entirely a matter of strategy, going back to what Brian was saying, because there is also a cost associated with it. And what we've heard is that even for a lot of large brand owners that would spend a lot of money in terms of monitoring and enforcement have chosen not to enter all of their portfolios or brands or marks or variations of those marks into the clearinghouse.
Brian, did you want to add anything?
Yeah, I think that's great points made by both my colleagues here. And I would add that if you put yourself back in my in-house position, again, I probably manage a trademark portfolio of hundreds or thousands of trademark registrations around the world. And it's not cost effective for me to enter every single one of them into the trademark clearinghouse. But for the crown jewels, it's a no-brainer. You know, for if I work at Delta, Delta, those kinds of marks. It absolutely makes
And
sense.
are you finding that the owners of those crown jewels are aware of this? Or,
Yes.
or are you breaking the news to them?
Yes, they definitely are aware
They
of
are
it
aware.
now.
Okay.
There was an educational component when the TMCH first launched, though, for sure.
Okay, Rebecca, I am so sorry. Rebecca Tischnett is the Frank Stanton Professor of First Amendment Law at Harvard Law School. And Rebecca, if you could tell us a little bit more about the trademark claims period and how that works, and then we'll launch into our kind of conversational discussion about these things.
Okay, so I guess with so much introductory stuff already on the table, I'll just say, new legal or quasi-legal systems are often set up using, assuming that they'll be used against and not by bad actors, because the problem that's most salient for before the new system exists is how do we deal with the current bad actors. Unfortunately, offline regulation and online regulation are the same in that bad actors find ways to game the system, whether that's by disseminating fake news or by claiming rights beyond what they actually have. It's also important that the devil is in the details. So when a policy is written, it may change substantially depending on who's implementing it and with what expectations. So as you heard, there are actually 2 forms of notice that might go out. When we talk about trademark claims, we mean the notice that goes to a potential registrant who is trying to register a term that's an exact match to a mark in the TMCH. Because there weren't enough acronyms floating around, the notice that the trademark owner gets, if someone actually proceeds to registration, we'll call that a NORN, just in case it comes up. So I just wanted to give a couple additional details about what's actually in the TMCH. So the top 10 queried entries in the TMCH, according to Deloitte's audit of what's going on. So these are, we don't know who put these queries in. all we know is that there was something sufficient to trigger a response from the database saying, yes, there is something in here, as opposed to no, there's not a match. So the top ones are Cloud, which is a registered Swiss trademark for pens, registered by a trademark lawyer, for himself, that is, for his own personal pen business. Smart, Love, Luxury, NYC, Forex, Hotel, One, London, and ABC. Other terms that reporting has identified as being in the TMCH: cash, rich, credit, the word the, VIP, global, hotels also there, mobile, prime, UK, virtual, Christmas, insurance, dating, discount, direct, social, construction, build, bet, vacation, and wedding. So one of the policy questions we need to address is that Microsoft and Xerox are not actually kind of the main things that are being returned in searches here, though those are probably also in the TMCH, don't get me wrong. Part of this stems from the fact that the clearinghouse has this global approach. If a mark is protected in any jurisdiction, it's eligible for inclusion. And if it's protected for any goods and services at all, anywhere in the world, it comes in and is sent out as a notice for all goods and services for all TLDs. Doesn't matter if the mark isn't eligible for protection in certain jurisdictions. You can see this in the debate over geographic indicators. So in fact, there's this incredible dispute elsewhere in ICANN and in trademark law over whether geographic indications are trademarks. But it was resolved in the implementation of the TMCH rather than by the participants in favor of including GIs. Doesn't matter if the word is generic for the relevant goods or services in other places, or even for other goods or services. So Cloud, for example, is of course not generic for pens, but it is generic for rather a lot of things that somebody might want to do online. And in addition, the TMCH has also made a decision in implementation to accept design marks. So, which is to say, there are a lot of marks that have graphic, non-textual elements. And what the TMCH, what Deloitte decided to do was, if it could extract from your submitted mark a textual element, then it would actually protect that textual element. So I have a couple of examples, I hope. So the M in the golden arches is the kind of thing, or the cars in the Disney Cars mark. So these are registered as, like McDonald's doesn't actually claim rights in M, Disney doesn't actually claim rights in the word cars, it claims rights in these marks. But in the TMCH, they would come out as M and cars. Just a couple of other examples of marks that you can see. As submitted, there are limited rights in what you have a design for. But the TMCH practice has been to accept these all and give people rights in the text as text. So a kind of really salient example actually is the American Physical Society has a journal called Physics, and they actually were able to get physics in the TMCH, even though the registration in the US is for the logo, like they had to disclaim the word physics. And in the EU doesn't have a formal disclaimer practice, but they still only register the logo. It's a figurative registration. But the TMCH extracts the word physics, and now in the TMCH, they have the word physics. So that's kind of my introductory part. I have some thoughts about what follows from that.
Mm-hmm. Okay. So I have a ton of questions already based on what everybody has said. And I guess, so I was careful to note your language, Rebecca. Twice you mentioned that in implementation, and I take that to mean as opposed to in policy development, decisions were made. Is that right? Yeah, so Mary, this will be a question for you. So what I heard Rebecca to say was that in implementation, GIs and design marks were allowed, and am I hearing that this was diverging from the policy development that happened in the process that you were briefly describing? Yeah.
Sorry, I thought Rebecca might have more to say. So I put my hand up to say two things, I guess. One is that one of the most fascinating aspects of my job is looking at how a policy is written, and how it's written goes through what we call the multi-stakeholder consultation process. And sometimes it's a little bit like treaty negotiations. What comes out at the end could be something that you know what it's talking about, but is fairly general in scope. And that's what happened in this case. This is my second point, in that the original policy recommendations that ultimately for the trademark protections translated into what we're talking about here today was really, really general. And I don't remember the words offhand, but it was basically something like, you shall protect the legal rights of others. So in terms of the implementation, it's important to remember then that everything we're talking about today, the trademark clearinghouse, the sunrise registration period, the 2 types of claims notices were developed as minimum protections during implementation of that very general policy recommendation. And I know there's a few people in this room who I sat down with during that implementation, looking at you, Jeff Newman, that had to translate that into something that was specific and that was workable. And then you had to design the trademark clearinghouse with all the technical specifications, appoint a validator who then developed the guidelines that Rebecca referred to. So all this is kind of a long-winded way of saying also in that when you come back to what Kathy was saying, that right now there is a policy working group within the ICANN community that's looking at all of this and is going to be developing, hopefully, policy recommendations that are clear, that are implementable, and that where things have gone too far in the past, rein them back in. Where things should have gone a little bit further, we can extend that protection after a few years of the new GTLD program. Then we get back to how do you translate that new policy into implementable measures. But everything we're talking about here today was developed through implementation of a very generally written policy.
So just a time out for the audience that this makes it so interesting, right? I mean, this is developing new systems, involves new issues that really have not been dealt with before. You know, it sounds like a little bit, Marion, correct me if I'm wrong, it sounds like you don't see a point in time where in the policy development, this issue was identified and explicitly discussed. Is that what you're saying?
So without getting into the details too
Yeah.
much, there was a working group during the policy development process that came up with this very general policy for reasons that I don't have to go into. So there was a policy development process that resulted in that policy recommendation. I think with respect to the specific points, say that Rebecca made for geographic indications, for example, I don't think that there was actually a group that sat down and thought about, oh, here are all the different types of
Right.
things that could or could not be protected. But I will say that during the implementation process, when we came up with the set of rules, if you like, that said, okay, you could have a nationally or regionally registered mark, you could have a court-validated mark, it was made very, very explicit that no jurisdiction should be excluded. So there were problems that would come up, and that was acknowledged, but it was felt, and I think this is important to emphasize, although it's not exactly the point you guys were making, in that neither ICANN, the organization, nor Deloitte as the validator are in a position to actually determine which marks are protected trademarks, which is more deserving, quote unquote. And so as a result, to the extent that you have these rules were made fairly generic and globally applicable.
Yeah, go ahead, Rebecca.
Yeah, so actually, this is actually a perfect illustration of the point, which is to say, when you say we're not in a position to determine this, there are actually 2 paths one might go down. So when you could say, look, if it's not certain, then we're not going to make the call, which is one version, which would lead to a smaller TMCH. If there's an argument for it, we're going to put it in. That's actually that's a different, but it's not a less judgmental opinion. It's just a different way. Once you identify the gray area, you have to decide, is the gray going to be in or out? And it turns out that's a pretty important decision. And I also will point out that the characterization here of GIs, like one could go on a whole discussion and never for once think that the question of if it's a trademark, it'll be in, would actually allow a GI in, because there's a whole bunch of people who think that GIs aren't trademarks and have a different relationship to protection and a different sort of ordinal value when assessing conflicts. So, and it's true that may not have been anticipated, but that's kind of the point, which is that that the implementer has important policy choices that were made in this case, always in favor of expanding, given that it's already protected anywhere, protected everywhere, protected for any good, protected for all goods and services. That has consequences.
Yeah, and it could, of course, be a policy choice as to unanticipated issues to cordon them off and wait for further deliberation, right, before making one of those it's in or it's out decisions. Go ahead. This is free for all time, my panelists, so jump in, don't
and
be
I
shy.
think some of these, you're seeing discussions that we are having and we have been having for the last few years on this topic. But one challenge and limitation of my job, for example, is that, again, I go back to the fact that policy is made at ICANN, and it involves a whole bunch of stakeholders with varying interests. So I wish I could sit here and say that we look at all these things, and then as the policy person, I kind of go, this is what I think is right. I can't do that. That's not my job, and I absolutely cannot do that. I would totally get fired like within 3 seconds. And I have board members sitting right here. So and actually, maybe they can speak to some difficult decisions that sometimes the board has to make, because where I was going to go with this is when you have policy that's developed by what we call the ICANN community that's gone through the consensus process, then that is something that goes to the board, which then decides is this policy within the best interest of ICANN or not. And then when they approve it, it comes back to my colleagues on the operations side to try to implement the policy as written. So I get it. It's hard. There are times that, and I know I'm speaking and we're being recorded, when I sit here and I kind of go, oh, is that really such a great idea? Let's try and make it work, because those are my instructions. Let's try to make it work.
Yeah, Griffin?
Thanks, yeah. There's a lot to unpack, I think, in what Rebecca said. I'm gonna, just to try and maybe touch on the GI point again quickly, since that's been sort of the topic that we've been on. I think the point that Mary made is an important one, which is, different jurisdictions kind of approach things from different standpoints, especially with the issue of geographical indication. So I think, the clearinghouse was kind of intended as sort of a baseline to make sure that, there weren't, certain jurisdictions weren't sort of being left behind, so to speak, by the way that, acceptance of certain rights were being implemented. So for example, just to kind of try and tie it to a concrete example, a concrete hypothetical example, if Italy protects, Parmesan, right, as a GI, somewhere in their national law, I don't know if that's true, but based on the underlying concept of what this mechanism is designed to achieve, you could point to, well, we did discuss that rights based in national law should be accepted, and therefore there's a basis for that. Whereas under U.S. law, you have to have a registration, a certification mark for a GI to be protected under U.S. law. So it's more about setting the baseline so that different jurisdictions don't receive kind of disparate treatment, I think. And that's one thing that's important to keep in mind in the GI context, at least. On the point that Rebecca made about sort of all goods and services across all TLDs, there's a lot of new GTLDs that aren't specific to a particular good and service, but you'd still might encounter consumer protection issues there and need to protect your trademarks in those TLDs. So things like .web, .online, .llc, or .inc, what's the good and service, right? I can't tie Delta Airlines brand to you know, a particular good, to exclude those types of kind of general TLDs where you may also want to protect them, right? And where they're no less ripe for potential abuse, et cetera, et cetera. So that's, you know, one important thing to keep in mind, I think, in terms of sort of the TLD or goods and service scope. And then on the point of design marks, I know there's been discussion about, you know, whether it's proper to, if a mark, and I see we have some nice examples here still on the slide of where there's a textual element that's contained with a design or a logo or stylization, et cetera. You know, again, I think going back to sort of the policy rationale for why this was why this took sort of perhaps a more expansive approach is, again, it's all going back to the underlying point, which is to protect consumers against confusingly similar uses of a mark in the DNS. And yes, you might have cars with a logo that's actually protected, but you know, if somebody goes and registers cars dot whatever, and then starts using it, you know, in bad faith to target the Cars, you know, brand of films, you know, again, I think it's appropriate to have that mark in the clearinghouse to both for Sunrise registration purposes potentially, but also the claims notice purpose, which again is to advise prospective registrants that these rights exist, and then it's up to them to make an informed decision as to whether to proceed with the registration, and then to inform the brand owner that this domain name has been registered if the prospective registrant then completes the process. So.
Okay, I know other panelists want to speak. I also want to speak, but go ahead. Kathy.
Okay. So if Michael were here, he would say, but Kathy, I read the rules. And that's what I have here. I read the rules that were created in the consensus policy by ICANN, the Special Trademark Issues Review Team recommendations that were adopted. It was an expedited process because it had to go quickly, but it was a group, every stakeholder in ICANN, as well as some of the advisory committees, had put groups on it, had put representatives on this, and it met for a very intense 6 to 8 weeks to finish up the trademark clearinghouse based on many recommendations that had come in. And if Michael were here, he'd say, but wait a second, these were the rules adopted unanimously by the GNSO Council that is responsible for creating the policy for generic names generally. And then it was adopted unanimously by the board. And let me tell you 2 things that it says and 1 thing that it meant. So it says the name of the rights protection mechanism should be the Trademark Clearinghouse. The original proposal had been IP Clearinghouse. Should be the Trademark Clearinghouse to signify that only trademarks are to be included in the database. Okay, so where's some of this other stuff coming from? That's what it was adopted as policy. It also says the Trademark Clearinghouse should be required to include nationally or multinationally registered text marks trademarks from all jurisdictions, and then adds a parentheses to make sure people understand the trademarks to be included in the Trademark Clearinghouse are text marks because, quote, design marks provide protection for letters and words only within the context of their design or logo, and the STI, the group that created this, was under a mandate not to expand existing trademark rights. So in ICANN, we've been creating policy for 20 years. We know how to write clear policy. And people who are on this committee, which, by the way, included me, did know how to write policy. We've been doing it for a long time, and we tried to be as clear as possible. Could we get everything clear? No. The other thing was that we debated the secrecy of the Trademark Clearinghouse, and we decided against it. The reason why was that most trademarks, at least in the jurisdictions we knew, are public for a very good reason. As Griffin has said, you want to notify the world that you're protecting your customers, that you have a brand that you want to differentiate. So we thought once you put those marks in the Trademark Clearinghouse, yes, let the world, let the innovators, let the world research what's there, what people claim, and then they can decide whether, you know, it lets them do their research in the nationally registered marks as well as in the Trademark Clearinghouse. So what happens? In implementation, and as a technologist, I don't understand this because this isn't what implementation is. And as a regulatory attorney, I don't understand this because this isn't what implementation is. But during implementation, we decided to accept GIs, even though they're not trademarks, at least, and they say they're not trademarks. I checked the World Intellectual Property Organization website on this. We decided to take design marks and extract words, even if they're disclaimed, and we decided to make the whole Trademark Clearinghouse secret. And this is where I've stopped understanding implementation or the purpose of creating consensus policies in ICANN.
Mary, I want to go to Brian next.
So I think it's,
Oh,
imp-
wait, wait.
I'm sorry.
Brian's in the queue, sorry.
Okay.
That's tough to follow. You can go.
You just want more time. Okay. No, I just wanted to make a point of clarification for folks in the audience, whether here or following along, that may not be evident if you're not, you know, a longtime participant in ICANN process. The implementation that I described actually started in 2008. And the policy in question was the one that I described, which is, basically you shall protect the legal rights of others. So the team that Kathy was part of, and there were other teams that several people in the audience were part of, that all happened during the implementation process. But the point that I want to make in all of this is that the implementation took probably 4 to 5 years, and there were various discussions, including what Kathy mentioned. But coming back to the consensus building process, the stakeholders involved, at each step of the way, all the various proposals were put out to get input from interested stakeholders and the community. So where we ended up, something that we call the applicant guidebook that guided the round when it opened. And it reflects basically a consolidated history of the 5 years of implementation stemming from that very broad policy from 2007, which is thou shalt protect the legal rights of others. I'm not saying we got it right or wrong, but that really was the process, and that's what happened, and here we are.
Brian?
Sure, thank you. My point is much less detailed than either of those. I'm curious to know, because when I was in the seats of many law school attendees here, I might not have known. Does anybody know why we, being the ICANN community, protect trademarks from any jurisdiction on the planet and not just U.S. trademarks? I mean, IANN is a California public benefit corporation. Does everybody know why we accept trademarks from any jurisdiction? No one country's law rules the internet. And so it's important for this community to allow trademark registrations and to protect rights holders under the trademark laws of all jurisdictions. And that was the policy decision way back when. I thought that was helpful background for folks.
Yeah, Griffin and then Rebecca.
Thanks. I just had two other quick points going to comments that Kathy and Rebecca had actually made previously. The first one is in the idea of expanding rights or giving people rights that they don't have. And I think we, as legitimate brand owners, definitely don't want people having rights that they don't have. But I think, again, going back to the point that I made earlier about kind of the rationale for some of the decisions that were taken as to what to include and what to allow into the Trademark Clearinghouse. Again, going back to the idea of the ultimate kind of consumer confusion test and the bad faith test that exists for trademarks and for DNS abuse. The idea of having cars, just a textual element, for example. I use that example again. If I register cars to something and use it in a way that reflects on the brand, again, I think that's not necessarily an expansion of the rights of cars, because if it's confusingly similar, if it's bad faith, then that still relates back to the brand. And so I think the rationale underlying that decision kind of speaks to that kind of test, because it's not just your exact match is protected and that's it, because there is a penumbra around the rights of trademarks.
In that exact typo, do you think that Disney would win a UDRP case?
I mean, depending on the use, sure.
Wouldn't it depend on whether they had a registration, whether they had a mark that protected the word cars?
Yes, but typically in UDRP, they would accept if you have a USPTO registration with cars in the registration.
So in other words, you're saying that in a UDRP in which Disney is concerned about a cars dot something, and all they had is a design mark disclaiming the word cars, you think that they would win if the site were particularly confusing?
Yes, I do. I think it's possible. Because cars is part of the mark. Yes, it might be disclaimed. You might not be able to register another mark on the USPTO register that would fall within 2D likelihood of confusion for that registration. But I think for purpose of the UDRP, again, because the point is it's about bad faith in the context of a UDRP, right? It's not necessarily the likelihood of confusion test in EDRP.
Correct.
So that's why I mentioned the two different tests.
Yeah.
Okay, but the point is the same. The rationale for why we would allow this into the clearinghouse in the first instance.
I actually think you're raising more of a question than you're answering because I think that if it's all about consumer confusion, then we deal with that with trademark law, right? We don't concern ourselves with the domain name. In the case of a domain name, we are concerning ourselves with someone registering a confusingly similar domain name to a trademark and the bad faith involved in that registration. So I think your hypo is a perfect example of a good trademark case, but not a good domain name.
Right, and but I think that's right, because then it goes back to what are we talking about today? We're talking about the Trademark Clearinghouse.
Right.
Okay, we're not talking about challenging the underlying registration. If you have a problem with the underlying registration, then challenge it in the jurisdiction where it's registered.
Yeah, except for the fact that we get this sunrise and claims notice that hinges on the
Yeah,
clearinghouse.
and so I'll mention that there are mechanisms to challenge what's in the Trademark Clearinghouse.
Oh, okay, I want to hear about that, but let other people speak.
Right. So actually, this discussion is a great way of highlighting just how far away from trademark we have gotten. So letting everything into the TMCH is a wonderful way to get much, much further from the consumer protection basis of trademark. So every axis on which you decide to allow more in makes it less likely that you are targeting things that are confusing or harmful to consumers. So cars is a great example because so once you have the TMCH, you've and Sunrise, which allows people to preempt. So if you're Delta, you get to register delta.cars, right? If you have Sunrise rights. So we've already abstracted away from consumer confusion and bad faith. It doesn't matter what someone else might use delta.cars for. They can't have it. And they get a notice if they try and register it, no matter what they're planning to do. And by the way, we do have some empirical research now that suggests that most people, most ordinary people, have no idea what that notice means, and are pretty easily scared away because they're not gonna know that they are not going to get sued from this notice. So once you're saying we're going to abstract away from what the GTLD is, we're going to abstract away from the goods and services, it's just going to be a text match, then every decision you make about including more and more stuff, including design marks, has more effects on things that aren't confusing. So just how many cars.whatever websites would you have to go through, do you think, before, of the potential cars.whatever websites, before one was about Disney sites? And yet they're all impacted by Sunrise and by the claims notice.
I just want to highlight one other thing that Kathy mentioned and was implicit in, I think, what Mary started us off with, which is Mary was talking, or a number of speakers were talking about the reports, what we know from the reports of what's been registered. And it is something just to pause and maybe discuss about the policy of making the clearinghouse secret and not searchable. I'm quite interested in the idea of a global registry, a global database of recordals, or whatever you want to call it, because there's nothing like that exists in trademark law up until now. And the things that come the closest are, for instance, WIPO has a database of state emblems and flags for the purposes of Paris Article 6 TER, right? But these are all very public, searchable documents. The whole reason for these databases is to put people on notice. So it's a curiosity to me as to why this particular database is not searchable, which would be a very easy way to put people on notice if the concern is not to have people registering someone's trademark in new GTLDs.
Thank you. That's a great question, and I think we probably all have a lot of views on whether the database should be searchable or not. To your point about putting people on notice, I made a note earlier, and I'm glad that we got to get back to this, that encouragingly to brand owners, having my trademark registered in the Trademark Clearinghouse does put potential new domain name owners who might cyber squat from my perspective, on my brand in a new TLD, it does put that potential registrant on notice that they may or probably are infringing on my brand if they proceed with that trademark registration. And that's good news for me. I want that person to be on notice. I want to be able to use that notice as evidence in my trademark case or my UDRP case or my URS case. So that's a good thing for brand owners. And I probably haven't seen the most up-to-date data that Rebecca was mentioning, but I was encouraged when I saw the first data come out about how often potential cyber squatters or would-be registrants, depending on your perspective, back out of that registration process once they're put on notice that they may be infringing on my rights by registering that domain name, by proceeding through. So the first data I think that came out on that looked like about a 90% bounce rate. And I don't know how many of those folks would have not finished up their cart action anyway. Do you have a clarification?
Well, actually, I'll wait, but yes.
Okay, good. So I don't know what the most accurate up-to-date data is, but I'm encouraged that folks are presented with that notice and then don't go ahead and, from my perspective, infringe my brand or potentially infringe my brand by continuing with that that domain name registration. And then I think the conversation about trademark law versus the trademark clearinghouse and domain name policy is a really important one. And there's a question that I think often surfaces about if trademark law is a better avenue or better perspective to look at these issues. And I probably, if someone infringes my rights on a domain name, if it's in a relevant top-level domain or uses a site that does have infringing content, trademark law may give me the clearest avenue to cry foul and to assert my rights. But from the brand owner's perspective, it's really impractical to march to federal court every time somebody infringes my rights on a domain name. Again, remember, if I'm Delta in-house counsel, I have a portfolio of domain names that my corporation needs that's 5,000 or 10,000 domain names at least. And I can't go to federal court every time somebody with $10 goes to their favorite registrar and wants to infringe my rights on another domain name, another domain name, another domain name. That's an impractical result. So while trademark law might give me a better avenue, if you just look, if you have a law school problem and you look at the exam in the real world, the TMCH gives me a benefit that I don't have, and that's the expediency of the result.
Rebecca, you, and then Mary?
Yeah, so this is actually
And Griffin.
kind of an evidentiary thing. So it turns out we have really poor evidence about abandonment rates, like really poor. And so for strategic reasons, it was actually trademark owners' representatives who were saying that 90% bounce rate meant nothing because it might reflect a bunch of automated inquiries, which might be true. Like I actually, our evidence on this is really, really bad. But just to be clear, that 90% abandonment rate was for people or automated programs that were looking at cloud, hotel, one, London. The idea that they were turning back because they were cyber squatters is not, prima facie not credible. Because it would be extremely hard to be a cyber squatter on cloud dot whatever. I mean, it's possible. There's a couple of valid cloud marks out there, but very, very hard. Not really where I'm putting my money. Now, we were not able to survey actual cyber squatters. I mean, it is true. It's a limitation of the data. So we don't really know anything about people who actually want to make fake sites. They don't answer our questionnaires, sadly. And so we are completely in the realm of speculation about the effects this has on people who actually plan to, try and get your Delta login information. My sense is that merely getting a notice is probably not the thing that's going to deter them. But, it's possible that better data from actual cyber squatters could, show that not to be true. What we have are surveys of people who identify as ordinary registrants. And they basically, their responses to interpreting the notice were basically no better than chance in terms of what it meant for them. So, I don't think, I'm not sure you could say the game is worth the candle at this point. Certainly, I think we need to be very careful when we talk about deterrence. Thank you.
Mary and then Griffin, yeah.
So I was going
And we're
to try and
coming up close
inject.
to our question from audience,
Exactly.
so let's
So
be brief.
to try and warm the audience up, I was going to try and inject a note of relative positivity here. If there's one thing that everyone who's participating in the current review process can agree on, is that before we do this again, we need a lot more data. And we need a lot more good data. That's actually, I think, the one recommendation everybody can agree on. Yay. So before going on to Q&A, just to go back to how I started my remarks, in that the Trademark Clearinghouse supports the two specific rights protection mechanisms, which are Sunrise and claims. That is not to say that there is nothing to discuss about the Trademark Clearinghouse. I think we heard from a lot of the panelists today that there are some very valid and serious concerns, not just about how it operates, but what goes in it, and that is under current discussion right now. There is an opportunity that in the next iteration of whatever the policy is, it could get much more specific than thou shalt protect the legal rights of others. And then we spend 5 years trying to figure out what that means, which is where we ended up in this particular round. But then I think it's also important as you go into this to try and unpack the two different rights protection mechanisms themselves. And from what we've heard from a lot of community members, there's concerns that are different about the Sunrise registration versus the claims notice. I think Rebecca and Kathy have talked a little bit about the claims notice and this concern that there's a bit of a chilling effect because someone gets a notice, they don't know what it means, and they could stop a registration even though they're not cyber squatting. That is a concern that's been raised. With the Sunrise, the concern is somewhat different, although obviously it has impacts in that Sunrise doesn't give you a substantive legal right. Right? It doesn't say, now you therefore have this extra right, but what it does give you is a priority registration. So in the kind of non-real estate that is internet domain names, that is very, very valuable. And in a different policy process, dealing with a completely different issue, we've heard concerns that giving that priority may be problematic. So it is important to look at each of these separately, but then to look at them holistically together and say, which parts can we fix? Which parts actually make sense? And that's kind of what we're hoping to do.
Griffin?
Yeah, thanks. I want to agree with things that Rebecca and Kathy said about the issue of gaming, where somebody has a registration in some random jurisdiction around the world, and through that registration gets access to the clearinghouse and the support mechanism. Legitimate brand owners don't want that either, right? We want a clean trademark clearinghouse, just like we want a clean, register on the PTO register, et cetera, for that, when legitimate rights owners do come in, there's not a conflict with somebody or et cetera, all the problems that can be created through that. So I do want to just point that out. As I think I mentioned very briefly earlier, there is a mechanism as part of the Trademark Clearinghouse system that allows challenges to records in the clearinghouse. And there are a few different varieties for that. So one is a mechanism for challenging a decision by the clearinghouse to not allow something into the clearinghouse, right? If you're for the trademark owner, for example, who was denied. But there is a mechanism for a third party to challenge something in the clearinghouse.
Which they will only find out about if they get a claims notice.
Potentially, yes, or a Sunrise registration, perhaps, that they become aware of. But again, if you're in good faith attempting to go register something that you want to use in good faith for a legitimate purpose, and you run up against a Sunrise registration or against you receive a claims notice for that issue, then there is a mechanism that you can work through the clearinghouse notice to try and get that deactivated from the clearinghouse, essentially, right? I take your point. Like there might already be damage done, so to speak, if somebody has already acted upon that verified record to get a Sunrise registration or something. But also important to keep in mind that registration itself can also be challenged if it is illegitimate for some reason. And then go.
No, not for illegitimate for some reason. You'd have to find it violated somebody else's rights. So
There are terms and conditions of registration that apply under registration agreements with registrars. But in any case, and then this goes back to the point about the confidentiality of the clearinghouse database. I know there's conflicting views as to whether and why that should be more transparent or not. I think the idea of keeping it confidential is important because it goes back to something Brian King said earlier, which was, trademark owners make strategic decisions about what they might put in a clearinghouse. if you have a multitude of different marks, you might only choose the quote unquote crown jewels, right? And that reflects kind of strategic information by the brand owner. And we don't want to provide a roadmap to what gaps might exist in a brand owner's portfolio for potential bad actors who might, again, abuse an open database, right? So there are concerns. I understand that, there may need to be additional ways of finding out what might be in there for purposes of legitimate registrations. But again, if you get a claims notice when you try to register something, then that's one way that you would find out. There are issues around that. I get that, but there are a multitude of reasons why that's maybe not necessarily the only way to go.
Yeah, I'm not sure. I'm not persuaded by that. It seems to me that we could say the same about a company's registration practices in different countries, what they're registering. People are monitoring that for these, strategic secrets all the time. It seems to me that it wouldn't take much for me to file a bunch of second-level domain names in these GTLDs just to get that information, in fact, and I would do that. And what you've both already said is that these different trademark owners act differently. So what one doesn't really bear on a unanimous, come on over, Michael's here, yay. You're just in time to answer questions from the audience, Michael. Yeah, anyway. I just want to remark on the last couple of comments about gaming the system, which I actually think is invited, totally invited, in the sense that you mean gaming the system. So there are two strategies to get a trademark in the clearinghouse. One is to go to the jurisdiction that is the easiest to get a trademark from, both cheap, fast, and will accept anything. And the other is to do something along these lines to try to get a GI registered, to try to get words that were disclaimed in a figurative mark registered. And, I don't know why people wouldn't just game. I mean, you can still get that way from gaming the system. I think that might be preferable. Because I'm a little bit concerned about the precedent that's set for letting in all these different things, such as, words disclaimed, specifically disclaimed, and GIs. So I attended a panel discussion at the last INTA, which was fascinating. Mary, I think you were there. You were on the panel. Talking about the protection of GIs in new GTLDs. And there were representatives for very valuable GIs who were bragging about gaming the system, exactly that. They were saying, and they said very clearly, we don't think GIs are trademarks. That's anathema. But all you have to do is go get a trademark in the GI, and then you can protect yourself in this domain name system. So they were kind of advertising that possibility. So, audience, to you, please come down to the microphones, and I think you might have to turn on the button to turn it on. And if you would not mind telling us who you are, and then we'd love to hear your question, and Michael is going to answer all of the questions. I think.
Is that working?
Yes.
Yeah, hi. Phil Corwin. I'm Policy Counsel at VeriSign. I'm one of the co-chairs of the RPM Review Working Group. I just had 3 factual statements I wanted to make, and if anybody on the panel wants to react, that's fine. They're not questions. The first is a point the professor just made, that while the Trademark Clearinghouse database is confidential, if I want to know if Acme Corporation has registered certain trademarks they own in the clearinghouse for whatever purpose, good or bad, I can simply go during the first 90 days of any new TLD's general availability period and try, with no intent to register a domain, simply enter them at any registrar, and if I get a notice back, they're registered, they're recorded in the clearinghouse. If I don't, then they're not. So, and we suspect that some parties have done that. Again, we don't know how many of the 94% of attempted registrations that got notices that didn't go through to completion were done for that purpose, were done by people who intended to cyber squat and were deferred, or people who didn't intend to cyber squat but got spooked. We just don't know. The data doesn't tell us that. a statement was made that domain names can't be trademarked. That's no longer true. Several weeks ago in the Fourth Circuit, which covers Virginia, which is the home to several major registries, the Fourth Circuit Court of Appeals ruled that Booking.com had demonstrated acquired distinctiveness and the domain could be registered as a trademark. I wouldn't be surprised to see that case go to the Supreme Court because of the split in the circuits. And if it's affirmed, if it goes there, or even if it's not, given that it's the Fourth Circuit, which covers Virginia, it's going to have implications for the domain name system going forward, which our working group may have to grapple with at some point. We're delighted to have another issue to look at. And finally, one thing I want to point out about the consensus policy process to create policy, and particularly to review existing policy like this, which is policy but not consensus policy yet, but it may be. That's a question before the working group. To get that through ICANN, you've heard a lot of diverse opinions on this panel. For a working group to report something to GNSO Council with any hope of having Council adopted it, it has to have consensus support, which means unanimous support or near unanimous. Strong support, like 80%, and we don't vote in these working groups, like 80% support but 20% dissenting, not good enough. Council's not going to pass that on to the board. The board's going to be gun shy, and then we also have that the Governmental Advisory Committee can play a role by putting in contrary objections to the board against a council recommended policy. So the working group is just the first step in a very difficult process to get things changed, which is why at the end of the day, as I said early on in this working group, the reality is, given that high bar, any changes we recommend by consensus will probably be incremental and not radical. Thank you very much.
Why don't, in the interest of time, why don't we hear all the questions and then we'll let the panelists respond. If you could just.
Can I just say, so just in case it wasn't clear, consensus policy means would apply to all the GTLDs, right? So that's actually the key implication for those of you who aren't completely familiar with this,
Okay.
as why would you be? The question is whether TMCH claims notice and things like that will be extended to .com, just so you know.
To legacy GTLDs, yeah.
Friends, I'm at the Internet Governance Lab, also a scholar at PIGIP here. So my question is primarily for Brian. So I've heard you speak about a brand, and I must admit, I'm confused. I teach IP, I teach about trademark, copyright, patent, design. I don't know what a brand is. Maybe it's something in the Homesteading Act that my legal education didn't cover, but I'm concerned this brand thing seems to cover things like, well, if I am Delta and I don't want sex.delta, then I have some kind of legal interest, and I'm not sure there is a legally cognizable harm there for Delta. If so, I'm not sure why ICANN should care or facilitate preventing that kind of speech. There is a legally cognizable harm in preventing some kinds of speech, like, for example, if someone's able to prevent sex.Mormon, we've got a First Amendment issue. So why speak of brands, and what legally cognizable harm is there for sex.delta?
Okay. Thank you for the question, but we're gonna, if you just note it, and we're gonna take all of them because I'm.
Hi, my name is Ashwita. I'm also at the Internet Governance Lab and a PhD student at the School of Communication. My question is to Mr. Barnett. Earlier when you were speaking about gaming the system, etc., you were talking about how brands could register themselves in a random organization or in like a illegitimate country or something like that. What exactly did you mean by you could register a trademark in an illegitimate country? Like, what's an illegitimate country or organization, something like that?
Right, thank you.
Susan Anthony, United States Patent and Trademark Office. I would like to thank the panel for an excellent panel.
Thank you. Thank you for being here.
The subject, of course, as several people can read on my knitted brow, is geographical indications, and that category 2 of marks protected by statute or treaty. I believe way back when people thought about marks protected by statute or treaty, they were thinking Olympics, they were thinking Red Cross. They were not thinking geographical indications. And I've had my head handed to me on a platter before in ever putting the word GIs and the word trademarks in the same sentence. I have been informed by many others who are steeped in this work that geographical indications are not marks. Please do not refer to them as marks. You will offend the Europeans, you will offend WIPO, and I don't want to be offensive. So, I did want to point out, though, that not all geographical indications are registered certification marks in the United States. As a matter of fact, the Trademark Trial and Appeal Board has found that cognac is an unregistered certification mark. So I didn't want to give people the impression that, or the misimpression that in the United States registration is required to have trademark rights. So you may well ask, what is your question, Susan? As you can see, this is a very burning issue for the USPTO. We have previously spoken about it publicly at ICANN, and we are very concerned that when it says marks, when it says Trademark Clearinghouse, we are talking about marks and not geographical indications. Does this issue remain on the table within the rights protection mechanisms, PDP-WG?
Great, thank you. Please.
Hi, I'm Judith Hellestein with Hellestein Associates and also a Navallo member. So my question is, so how does GDR impact the rights protection mechanisms? Because we're revamping through another expedited PDP, the WHOIS mechanisms and what information is stored and how does that impact upon what we're talking about now in the rights protection and the trade thing when as you explained, some of the information they rely on is getting from these vendors when the domains may not have agreed on what is out there or what can be saved or what's not scrubbed from the WHOIS system that they're contacting. So that was my question.
Thank you. Wonderful questions. Panelists, we're due to have a break. This audience would like to have a cup of coffee. So be brief in your response to these excellent questions. And can we begin with Michael, since poor guy came all the way from Toronto and just arrived. So anything you would like to say in response, Michael?
Sure, thanks so much for that. And apologies for being late. Our major airlines were conspiring to keep me from this event. It was not Delta. It was not Delta. Just in response to some of those remarks that we heard just now, yes, in terms of the transparency of the database, it is possible to go through and manually input particular terms to see if they're registered in there. That is indeed how some of the abuse, which hopefully was mentioned, like terms like Christmas and pizza being protected in there, that's how that was uncovered by savvy journalists. As the practicality of using that as an oversight and monitoring mechanism is simply not there, though. Functionally, you can look for individual terms, but you can't use that kind of a system in order to get a broad understanding of how the system is working, which I think is vital to having proper accountability by civil society and by academics in terms of understanding whether the system as a whole is working as intended, or if abuse is a few scattered instances, or if it's widespread, or if it's the lay of the land. The transparency issue is very important. I'm sure it was discussed earlier, but I do think that while the ability to go through it individually can provide a little bit of an illumination, it's not an actual solution to the problem. In terms of the incumbency, I also want to pick up on what Phil mentioned regarding the fact that if there is not consensus to change the policy, the status quo tends to prevail. And the necessity of getting this consensus in order to implement changes, that's particularly problematic when you get a situation as we have here, where the implementation is drifting from the rules as originally designed. And that's specifically the case when it comes to accepting design marks into the TMCH. That's something that is completely turning the original rules on their head. So when you have a system like that, where Deloitte is moving from the original system to a completely different one, and one which facilitates all manner of abuses, music as a trademark for music, Apple as a trademark for fruits, it leads to, I think, really important conceptual challenges in terms of that model of decision making. Because obviously, if you're on the side that's beneficial, that benefits from that, you're going to oppose anything that weakens that consensus, even though, or that status quo, even though it's not the status quo that actually flowed from the consensus that was arrived at. And I also just want to say briefly that when we talk about transparency, when we talk about accountability, I think that this is all important as a matter of trademark law, but I also think that this fundamentally leads to very challenging questions about ICANN and its position in the internet governance landscape. Transparency and public accountability is fundamental to what ICANN does. And if you don't believe me, look at any press release, any annual report that they put out there. Transparency, transparency, transparency. I was the rapporteur for the transparency subgroup. I'm now on the ATRT review team for accountability and transparency. Transparency is everywhere in ICANN's communications. And it's fundamental to what the organization presents itself as, and it should be fundamental, because without that level of public accountability, it is very difficult to justify ICANN's role as stewarding this critical global public resource. So fundamentally, I think this goes beyond just the question of trademark enforcement and speaks to broader questions where the fact that you have this database that impacts a lot of people's rights and plays this critical function at ICANN, and the transparency for it isn't there, I think that's a fundamental challenge to ICANN's role in the internet governance space. And similarly, when we talk about advancing, Right, so I think that this is a fundamental challenge. And the other thing that I would add, which again, I apologize if this was mentioned previously, but I also find it troubling if ICANN is being used as an institution to advance a model of trademark enforcement which goes vastly beyond the protections that would be offered by any particular governmental system. It's a maximalist approach where if you can get any level of trademark protection in any jurisdiction, you get the maximum level globally. That's fundamentally problematic. And if ICANN is being used as a vehicle to advance these new understandings of intellectual property rights, that also is, I think, very troubling in terms of ICANN's role in the ecosystem. Thank you.
Other panelists don't get that long to respond, but given the ratio of time it took him to get here to minutes speaking, we'll allow it this time. Yeah, we'll just go down the line and then anybody can respond, but do try to be brief so that we can have a coffee break.
I'm going to try and take a stab at Susan's question and Judith's. And actually, if I really wanted to be quick, the answer to Susan is yes. It is under consideration. But I just want to add a comment to that. And here is probably something that the working group will come to talk about as part of doing the work in this phase, which is that the category of marks in question is mark protected by statute or treaty. The word mark is not actually defined in a lot of national legislation, but it is defined in some. So to that extent, what you said about what is a mark, and I think, Rebecca, you said something similar as well, it may not be so much as to whether something is or is not AGI, or whether something is or is not an AOC, but whether the thing is indeed a mark that's protected by the statute or the treaty. Judith, to your question, to some extent, the current expedited policy development process has already taken some of the general data protection regulation issues into account. And this is particularly for filings of the complaints under the Uniform Dispute Resolution Policy and the Uniform Rapid Suspension System that Christine mentioned a while ago. And that actually is in the temporary policy that the board adopted, and that's going to run until it's either expires or gets supplanted by a new consensus policy. To the extent that we're talking now about the Trademark Clearinghouse, and to the extent that the current terms and conditions don't cover some of the obligations with respect to collection, display, and processing of information, yes, and I would expect that that will need to be addressed as well. Thank you.
So first, I'll just quickly respond to the question that was directed to me. I don't think I used the word illegitimate for different jurisdictions in terms of trademark registration. Hopefully I didn't. But what I think the concept was intended to refer to was that there are differing examination standards in different jurisdictions, right? And some you might say are have a somewhat lower bar to completing the registration process than others. Some don't have, upfront proof of use requirements, et cetera, et cetera. There's different standards is the point. And, so it's just a matter of taking into account the different examination standards. So that hopefully that answers the question that was directed towards me. And just a quick number of final quick points, hopefully. One thing that was talked about earlier is data, and there's some data that suggests that people got a claims notice and were deterred. One thing that I hope we all agree on is that the wording of the claims notice can be improved so that we don't kind of over-deter people who are what we might call an innocent infringer or somebody who's looking to register something they don't really know better. They might be trying to get it for a legitimate purpose.
And I submitted a model written by students here at this law school.
Oh, well. Oh, okay. I'll have to take a look at this. Mary already kind of addressed the issue of the impact of GDPR on RPMs, so I don't think I'll go there. Thought I had one other point, but I don't, so I'll end there.
Oh,
Thanks.
thank you.
I'm going to yield my time.
Okay.
I have a couple quick points to rattle off here quickly. One is that we use, I think it's good for discussion to use the word cloud as an example of something that could be trademarked in a jurisdiction but can be widely considered generic as well in a number of cases. I think you have to be careful when you have that discussion, though, because I want to say that one of the most valuable trademarks in the world is Apple, and that's also generic. It's a piece of fruit, too. So I think we need to think about how hard it is to make the policy determinations that we need to make when those kinds of situations exist. So that's one point. To the question about what is a brand and why protect it, that's a hard question too. A brand is a shortcut that we often use, and it's worth unpacking, I think, maybe outside at the break, because it means a lot of different things, right? I think we use it as a substitute for intellectual property. Intellectual property often means trademarks, it can mean copyrights, it can mean trade secrets and our secret sauce. And a lot of that is protected by law, and it's protected differently in different jurisdictions. And why protect it online is contained in the ICANN bylaws and in ICANN's mission. And so there's a lot of disagreement to be had about that too, from lots of different areas of the community. And so to the question about GDPR and how it impacts rights protection mechanisms, I can tell you it hasn't been good. It's really been hard. It's been bad for intellectual property owners. It was hard enough, I think, to track down who the counterfeit producers were, you name it, the bad actors online. It was hard enough already, and now the fact that a European law that impacts personal data has been applied to non-European contexts and data around legal entities and not individuals has been hard, and it's made our jobs a lot harder. And there's a lot of data out there. It's not reliable for law enforcement or for brand owners. Access to who owns a domain name is not a reliable concept anymore. So on May 25th last year, that all changed, and that's a big problem for us. And we're working hard through the EPDP to address it. I'm not as optimistic as I was going into it about where we would end today, but it's not over yet. We're still working on it.
And very quickly, since it looks like I get the last word, so I have a question for you. Didn't I do a good job channeling Michael? And I'll just add as we go in that it's very different, that one of the things we really need to understand is what's the baseline? What were the rules that were adopted? Because once the baseline moves, once geographical indications are inserted, then how do you reset? Resetting's really, really hard, even if there's a review process going on. So where the balance tends to take place in ICANN, the best balance, the balance between intellectual property rights and the public interest is when those rules are negotiated originally. And if they change during implementation, it's very hard to reset.
Okay, 90 minutes. Objective one was to have disagreement that led to a productive conversation, check. And second was to demonstrate that this is totally fascinating, check, check. So you've earned a break. Please join me in thanking this amazing group of speakers who did such a great job. There should be coffee outside, and then we'll come back in here in 10 minutes. Thank you for coming and filling in. Yeah, that was fantastic.
Had a lot to blow up there at the end.
Yeah, you did a great job. And thank you for dealing with the who is question.
Oh, sure.
I was hoping you would address the who is question, Brian.
I was hoping you would.
So, Kathy, I'm going to put this up now to get it ready.
Oh, no, can you put the other one?
I only got one.
Because that would be a great slide to put it right now. Symphony, because it's just upstairs.
Did you send them both in the same email? I did. Oh, then I just didn't notice it. Sorry. Right. That was great. Yeah, that was great. Yeah, that was great. Yeah, that was really good. Yeah, that was. Yeah, no, that was.
Oh, slides for the event.
Oh, you got it right there?
Sorry, I'm late.
Hi.
Better late than never, I guess.
Virtual hug. Thank you for coming. Just in the nick of time. We're trying to find a slide.
Oh, there we go. Okay, so this one.
Yeah, that one can go over.
Okay, thank you. Just this.
Yep, just
Oh,
that.
that's awesome.
Yeah, isn't that great?
That I don't think we have a problem with. Makes it easier just to have one thing and not have to jump around. I think it was really effective to have the slides that we had for that one.
Yeah, no, because it's so technical. It
Yeah.
gives people a chance to.
Yeah.
use their
And
heads
those
look at
examples
it.
were great.
Of course, and that's why I put up things like. There it is. Nice. And then how do we switch when we, hi, good.
You don't remember me.
You look so familiar. My,
Greenberg and Leary.
of course, I went here, I heard you speak last time at Global Congress.
Right.
Yes.
Really glad
And I have a question for Christine before she, how do we switch to my other side? So we'll-
Oh, you want those too?
I want
Okay,
those
let
two,
me,
but
I didn't realize. Okay.
This is for the intro.
Okay, let me get that. I'll get that up.
incredibly glad you brought it because I was just like,
It gets me a lot of trouble.
but you're right.
You were so articulate.
No, you
Do
shouldn't.
you guys know each other? Lorraine, Steve? I heard Stephen speak at Lorraine, Federal Trade Commission.
They're both there.
Okay.
So you can just minimize, and then you can get this one, and then you can just maximize that one.
Okay.
If you want me to, I'll run up.
Yes.
Okay?
Okay, if I can't do it, will you
Yeah,
save me?
I'll save you. It is. Let me see now. I'm having trouble with that. Okay. And then we're gonna go maximize.
Okay.
Yeah.
I mean,
I'm gonna sit really close, so no worries.
Christine, this is my daughter Rebecca.
Imposter scams, even in this road calls, things that I'm sure delivering peptides
Can I offer you like someone tried to call my dad a couple weeks ago and pretended to be me in the hospital.
No, they're terrible, and they're very good at what they do.
He called me all wrong. Oh man, he's 92 years old. Doesn't really have a clue about all this.
Well, they'll tell them you can't call them.
Right, yeah.
Take away the deal that we're offering.
Yeah, no, it's horrible. Yeah, no, they are vile, vile human beings.
Yeah, please.
That wasn't too
Yes, I left mine at home. I pulled
Oh,
out.
you're used to it.
You do a lot of takedowns.
Well, if you're doing the, yeah.
Yeah, I don't want to do that. I'd rather we do the work and make the money. But yeah, I was monitoring.
you could,
Right. I like the take down some showing. One, I get to go there sometimes.
Oh, do you?
Yeah. Let's go knock on doors. Oh, have you ever gone on a raid?
That's awesome. We're doing training with some customs and border folks down here in 2 weeks.
We've done a couple of border stuff.
Never any real raids.
I've only been on one. It's just an amazing thing. You gotta
My
get guns.
title.
We went there, they had almost 40 police officers. It was wild. I'm sitting in the car, for that in the car. Yeah, it's like, oh my God. Hey, you gotta find something, right?
And sometimes I not until like a week ago, maybe.
I only knew because Kathy told me. I said, "Oh, I can't talk to you now because I'm working on finding my information for my panel."
Yeah.
And then she's like, "Oh, you definitely should come to this panel." And it's like, but they did, you know.
Yeah, I hadn't seen anything advertised for it until
Jolly, we got Jolly on the filming.
yeah, but where is the camera? Oh, there?
He's taking the live feed that AU is doing.
Ah, gotcha. Good. I'm sure you can stop me there. We'll try. I guess go around this way.
I will.
Oh, that's also. I'm sorry.
We lost Dan.
Please don't understand that we were ready to call them. Who's here?
So you came from another event?
I just had a
Wow, that's crazy.
for a whole different project. Project on fire.
Interesting.
It was actually really interesting. And it's about how they can put their use rights in soccer.
Wow.
It's super important. Digital culture is traveling.
Yes.
And our only saviors are these guys who Busy Cal still works in case you wanted to rerun any of the data that somebody did it as an experimental in 1987.
Yes, most of it just disappears, right? Or it's obsolete.
Well, this is how the first Excel spreadsheet. And it was like, just everybody adopted it, and then Microsoft okayed it. And it became obsolete. A huge amount of work was done in spreadsheets.
So they're training.
So those guys are now had experience in busy documents. And then they have questions like, can I make a presentation talking about this topic? Because
those kinds of questions. Yes, so it's kind of exciting because they keep saying, but can I? And you're like, it makes them feel good. Yes. Okay, yep. You're where you should be.
The Windows shop. Oh no. We're just like, no, it's not gonna work.
They won't give you any communication.
Do you want to join me in standing up, looking at the screen? That's why I figured out. I got like 4 minutes. These people play it just not as good. I mean, I'm happy to do it. Honestly, I didn't look at it right. I sent it to you on the mix. This one's on.
Does everybody have a bio or no one? Anybody want a bio here? Bios, people.
Oh, in your honor.
Okay, any more? What's the walking tour? All right, I'll leave from here. Christine, should we go? Thank you all for coming back or joining us for this panel. Really excited to be here. Really a thrill. Even more exciting to see people sit down. Good work, people. Good work, people. Our job is done. No, okay. I'm Pat Aufderheide. I'm in the School of Communication. And it is my great pleasure to work on various projects here with wonderful people at the law school like Christine Farley. And it is just a real pleasure and an honor to be here with people whose knowledge of the topic we're going to discuss is very deep, unlike my own. This is what we're going to be talking about today is an emerging phenomenon in internet domains, which is what some people are calling the walled garden. So this is, does anybody remember, is anybody old enough like me to remember the term walled garden from the days of AOL? AOL heyday, there you go. So in those days, AOL was promising you that it was going to provide you a safe place to be on the internet. And it would offer you everything you really wanted to do, kind of a proto-Facebook if you want. It would let you, it would give you the kinds of things you wanted to do by showing you what you wanted. And it would, of course, limit its offerings to things that were AOL or AOL associated. And it actually, things turned out differently than what AOL had in mind. But that was then, and now this term has arisen, and it arises in a whole new context. And it might or might not mean something different, but it certainly has to do with with registries creating terms within which anybody who participates, their registrars, their registrants, share certain common terms. So I think that the goal today, in following in Christine's excellent footsteps here, to have a productive conversation among people who have differing views on this same phenomenon. We're going to start out finding out the basics. In this new environment, this term that has arisen, walled garden, what does it mean to the different panelists here? Now, everybody, I hope, has a bio sheet, because these people have led awesome lives and have an amazing position on the internet. So there's no point in my spending the entire panel reading their bios. I'm going to first turn to Becky Burr to address this question, walled garden what?
So when I talk about walled gardens, I will have to say I'm a gardener. I live in a place with a lot of deer, and I think walls are great, and that's what I think of a walled garden is. But I know that's not what you're talking about. But I think that it's critical to contemplate this as it means something different to everybody. We used to talk about a .kids, for example, as a top-level domain that would have been a walled garden where content in that area was essentially, it was moderated content, and it was reviewed and deemed appropriate by some standard for children, and it was an available, safe space where people who were inside the walled garden were known and supposed to be inside the walled garden, and people who might take advantage of people inside the walled garden couldn't come in. That was one form of walled garden. I think lots of us have had a lot of experience trying to make that kind of a walled garden work, and it hasn't worked all that well. There are other walled gardens which are more general. It's open to anybody to come in to register a name, but there are certain rules that we have here. So if there's a dispute about a registration, then my rules as the registry that's operating this space are that, you know, I take it down in my own discretion, or I have a trusted notifier who tells me whether it's a violation of some kind of standard, or I have a third-party process that provides due process. That sometimes when we're talking about walled gardens, people will talk about that as a walled garden. I think other flavors of walled gardens are, I am a very large bookseller, and I run .books and sell books that I publish, and only that only I publish. And I think the variety goes on. So I think it's pretty hard to make general statements about whether walled gardens are good or bad, because it depends a lot on what you mean and how you operate them.
Okay, and Sarah Deutsch, are closed generics, are they walled gardens? And give us a notion of what a closed generic is.
Is this on? Oh, here we go. So talk about closed generics as walled
Are they walled gardens?
Well, to me, it really depends what we're talking about when we talk about the garden. So if the garden has high walls, it doesn't allow other people in, and there's bad activity happening inside that space, and it's restricted to one competitor, for example, and not to others, and perhaps that would be an example of a closed generic that is walled off. There are other spaces Becky mentioned that might just be regulated. So they might have requirements before they let people in. That could also possibly be a walled garden. But I would say generally, and we can get into this more when we talk about closed generics, but a closed generic is usually a closed space where somebody is taking a word from a language, a generic word, and taking it out of circulation, and they're saying, I'm the only one who has exclusive rights. You know, the domain name system operates by means of scarcity, so it only allows one person to operate that that domain name, but you're essentially giving them the right to take a generic word and then have exclusive rights over running it and who gets in or out of that space.
So L'Oreal wants .beauty.
Yeah.
Okay. Kathy Kleiman, Walled Garden.
I was hoping Christine could help us change the slides. Thanks. So we put up a slide here just about the variety of new GTLDs. So you can see new GTLDs in different languages: Chinese, Arabic, Hebrew, Cyrillic, as well as geos, .paris, .london, .nyc, brands, Google, Ericsson, Gucci are all on there. And those serving wide groups that involve interests, hobbies, all sorts of things: cooking, art, shop. So I just wanted, I just wanted to show a little bit about kind of this great promise of new GTLDs as we're switching slides. These are all GTLDs that have been delegated, that were applied for and delegated. But this is my slides, some quick slides, in part because there's a lot of material about walled gardens. Okay, so we didn't have walled gardens when ICANN was founded. We agreed that the internet was a public resource, and the Government Advisory Committee even told us that management of a GTLD was in the public interest. That was a 1999 communique. And when I was director of policy for .org about a decade ago, and Alexa Rad has left now, but she was my CEO, we took very seriously our role as stewards of the internet. As registries, we were responsible for the security and stability of the top-level domains. We protected the internet infrastructure, and we took down domain names that were abusive, but they were abusive to the infrastructure, malwares, botnets. We stayed away from content, because how did we know what's content infringement on site and absent due process? We also the laws on content differ all over the world. What's legal and protected under the First Amendment in the United States can be illegal and criminal in China, such as pro-democracy websites. We felt it wasn't our job to be judge, jury, and executioner on content. And around the same time, the country rejected SOPA and PIPA, the idea that law enforcement could ask to block access to an entire internet domain name due to infringing content based on a single post or web page. And so we protected speech, domain names, and due process. But a funny thing happened on the way to the new GTLD program. And ICANN thought they needed a place to put compromises after communities and governments raised questions and negotiated through the ICANN board, actually, on changes to new GTLDs. We needed a place to put them. And so ICANN decided to open up the contracts, the registry agreements that ICANN signs with the registries to certain voluntary commitments that the registry agreed to make. But registry applicants slid a lot of other stuff in there, and for some reason, ICANN let them.
Do you want this one?
I would like the next slide, please.
Okay, got it. Yeah, I'm sorry, I don't know how to.
I'm going to talk about okay, so registry, I've been told to keep talking. So registries adopted these voluntary public interest commitments that aren't public interest at all, and don't protect the public or the registrants in many cases. So Donuts, as has been mentioned earlier, big portfolio applicant, over 250 top-level domains, wrote its voluntary commitments to protect rights protection mechanisms beyond the consensus policies, beyond what you were hearing in panel 1. This is the panel I was really supposed to be on. They created a protected marks list that allows a trademark owner to block their trademark in the trademark clearinghouse across all of Donuts' top-level domains. This was actually policy negotiated and rejected by the ICANN community. They went on, and I just put this up so you don't think I'm kind of making it up. So, read it at your leisure. I'm happy to send you the slides. But the one I love is registry operator. This is Donuts across all its top-level domains. Registry operator reserves the right, at its sole discretion, at any time, without limitation, to deny, suspend, cancel, or transfer any registration or transaction, or place any domain name on registry, lock, hold, etc., including to comply with the terms of this registry agreement and the registry operator's anti-abuse policy, and also to protect intellectual property. And in another place it says to protect against the infringement of any copyright or trademark. again, beyond ICANN consensus policies, we're creating a walled garden where across 250 top-level domains, many which are very general, suddenly have their own content rules. Minds and Machines, which is the next slide. I got it. Sorry. This is just quick. It kind of has the same acceptable use policy, but then goes on to say that they'll work constructively with law enforcement to address reported cases of abuse. What law enforcement? Where are they? What jurisdiction? Pursuant to what due process? Based on mere allegation? And trust me, law enforcement asks registries to do a lot of things based on mere allegation. It looks like the registry is reserving to itself across many top-level domains the right to do anything it wants with the content. So what's really interesting, and again, I'm covering a lot of stuff in a short period of time, is ICANN has a limited mandate. And we were really excited with the transition from the US government that ICANN's new bylaws very expressly adopted a very clear mission. Article 1, mission, commitments, and core values. The mission of the Internet Corporation for Assigned Names and Numbers is to ensure the stable and secure operation of the Internet's unique identifier system, and ICANN shall not act outside its mission. ICANN shall not regulate services that use the Internet's unique identifiers or the content that such services carry or provide outside the scope of Section 1.1a. But a funny thing happened on the way to the bylaws, the revised bylaws. And every lawyer in the room will love this language. Whoops. Notwithstanding any provision of the bylaws to the contrary, we're adopting and embracing everything that was in these voluntary, not so public interest commitments. And we're embracing things that look a lot like it in future registry agreements. So a question for the panel and for everyone is, what's left of ICANN's multi-stakeholder model, and what continuing role does ICANN serve? Sorry, tough questions for today, but that's these walled gardens, these creations of content rules within a top-level domain. And I'll give it to Jeff, who I know has a differing opinion.
So, Jeff, the picture that Kathy Kleiman has painted here is rather bleak. And is that your understanding of what a walled garden strategy would be?
No, in short. And Kathy and I have had many conversations about this. But first thing I do want to say is I am one of the co-chairs of the subsequent procedures policy development process, which is working on the policies for the next round. My job there is to be neutral and run that in a neutral manner. So the viewpoints I'm expressing today are my own or my company or my company's, but not necessarily the way that the policies are going to turn out. So I don't want anyone to think that because I'm going to voice some strong opinions that that's the policies going forward. So a couple things, and Kathy really has given a lot, but what I'm going to talk about are points that are a little bit different than the way Kathy has put it. So if you look at what the original policy behind the new GTLDs was, or policies were, it was one of the reasons was to promote competition in the provision of registry services, to add to consumer choice, market differentiation, and geographical and service provider diversity. One of those elements, and we have to think about, there are two types of communities for which we need to promote choice. There's the registrant community, and those are people that would like to register domain names. But as Griffin pointed out on the last panel, and Brian, there are also the ultimate end users of the space who may or may not also be registrants. So when I think of walled gardens, there are three types I think of what's been mentioned. The first are registries that have restrictions, or otherwise called validated top-level domains, that they only allow certain entities in if they meet certain restrictions, and they kick them out if they don't. The second type is closed generics, which, as was said, was taking a generic word, or what may be a generic word, and using it solely within your own organization or your own organization's affiliates. And then the third issue I think we kind of talked about being walled gardens are the ability to take down names that are believed to be violation of your policies. I can make an argument, and will during this panel, that all three of those can and are good things. And the thing kind of as a generic type of comment is, when you look at organizations now that are facing increasing scrutiny for the content that is delivered over their system or through their platform, the heat on these organizations is getting very high. Whether it's Facebook being criticized for allowing deceitful misinformation, fake news being dispersed throughout their system, or in this case, whether it's a domain name registry that is being criticized for allowing an increasingly number of abusive domain name registrations. You have to also take a look at this from the side of those entities. I wish I could say, and I helped run a registry for a number of years. I wish I could say it was as easy as being able to kind of say, yep, we don't regulate content, that's it, we're stepping out of it. But when you work for these registries, and when you see some of the things that I've seen, including child pornography, including imminent threats of harm, including such obvious counterfeiting and distribution of movies and music, when things are that obvious, and you know that if you allow that activity to exist, then you will be criticized for having that activity in or through your platform, then the choice and the decision of whether to take down that content is not as simple as we don't look at content and therefore we let it go. And I have seen actual threats against human life, car bombs, and other types of things. And you know what? All of us, we're human beings. And you know what? If I see something that looks like an actual threat to imminent life, I'm going to take it down and take the heat for taking it down, because I'd rather take that heat than take the heat of some actual act that was actually committed and someone died. So not all situations are that extreme, but not everything is as easy as saying we don't touch content, let's move on. Thanks.
So your three categories for walled gardens would be content regulation at the registry level.
No, I wouldn't say content. Taking the ability to have policies like what Kathy was mentioning, reserving rights to take down names that violate certain policies. Right, so it's post registration.
Okay.
So there's three types. One is closed generics, which is an organization having and deciding on keeping that name for its own organization. And
.amazon, .beauty.
Well, not .amazon, but Amazon having something like .book.
Yeah, I'm sorry.
Right?
Yes, sorry.
And then the second type would be like a .pharmacy, .bank, which are restricted and only allow certain entities in. That's prior to allowing domain registrations. And then the third is a post-registration takedown process for abusive domain names or violations of policies.
Correct, okay. So Mitch Stoltz, is that categorization making sense to you to define what we're talking about today? And if so, how are you positioning yourself so people can understand your take on this?
So I may be fighting the hypo here, but I'd actually like to get away from this question. Is something a walled garden or not? Because we could come up with a definition, which would take us weeks, and then we argue about who's in and who's out, and that would take us weeks. As a concept, it's useful because it's useful to talk about gatekeepers of speech on the internet, of which there are many varieties. And it was actually really interesting that Jeff mentioned Facebook, because that's the one that sort of on the public policy level and academic and just as individual human beings we are all really wrestling with right now, and that's that Facebook has an incredible amount of power over who gets to speak and who will hear it and what subjects can be discussed, and everybody has a different opinion about how they should do it. some people think Facebook, of the Facebook's content moderation is biased against conservative viewpoints. Some people think they're allowing too much sort of false news. Some people think they should categorize their advertisements differently, right? But Facebook is a private company, so nobody really disputes their right and ability to moderate and to make those decisions. Although we all have an opinion about what's the right way to do it. Now, there are other sorts of gatekeepers. Your ISP can potentially be in the position of a gatekeeper. Your internet service provider can cut you off entirely if they so decide. And then the domain name system is another one, and that's a gatekeeper for anyone who owns a website, right? And for those who are looking for the open web and looking for an alternative to the mega platforms like Facebook and YouTube, it's still true you can make your own website, right? On which you can put almost anything, and there is no aside from legal process, there's no gatekeeper. There's nobody looking over your shoulder and saying what you can say and what you can and who can hear it. Or is there, right? Because if you have a website, you need a domain name. And if the companies that manage those domain names, and particularly we're talking about registries, I know this name was mentioned, and for people not steeped in the ICANN world, registries are companies that operate the top level domains. So for every word that comes after the last dot, there is a company that owns and manages that. So .com is managed by VeriSign. 250 odd new domain names are managed by Donuts. There are many others, and they effectively do have the power to make a website disappear by suspending its domain name. Especially if in a time-sensitive situation, that is the power of censorship. Right? They can throw, so just as Facebook can delete your posts almost at will, a registry can make your website disappear almost at will. That's why the policies like the one that Kathy showed, are scary to people who care about the open web and about free speech, because this is a private company with its own sort of business motivations and its own sort of independent decision making, exercising arbitrary power over speech. Now, certainly you can say, and this also to Jeff's point, different registries can do it differently, and this is very important, right? I mean, .com really has never historically had policies like this. There may be one-offs, they certainly, I'm sure, will suspend a domain name, on a court order, or if a domain is, being used to operate a botnet or something, things that we think of as technical harms, because we think of those technical harms as part of the administration of the internet, right? If one domain is sending out a whole bunch of spam and slowing down everybody and jamming up everybody else's email box, then maybe a company will shut that domain down. But the further we get from that, the more the registries are starting to look like Facebook in the degree of power that they're wielding over speech and the audiences for speech. And also, the more they do it, the harder it is to stop. So absolutely, any sort of person with a conscience, if working at one of these companies, if they see, a threat to human life, they're gonna go in there and shut it down. But the more we do that, and the more that's done, the harder it is to say no to the next one. And this happened, this is an example not in the domain name space, but something very close to. There's a company called Cloudflare, which is a content delivery network and caching service that basically speeds up websites and insulates them from denial of service attacks. Very large company. the last statistic I heard, they were processing, something like 7% of all web pages, websites in the world had Cloudflare as an intermediary. The number's probably higher by now. But 2 summers ago, the CEO of Cloudflare said, this morning I suspended, this was a neo-Nazi website that was, inciting violence. And he said, and he wrote a very interesting letter where he basically said, I got up on the wrong side of the bed this morning and I made this website disappear. And my conscience told me to do it, but this is a dangerous power for me to wield. And I shouldn't have the power to do that. And it turns out he was right. Like his prediction proved true, because a year later, Cloudflare was sued by a group of record companies for, I believe it was record companies, but copyright holders for supposedly allowing websites, allowing a website to infringe copyright and providing services to that website. And the people that sued them, they said, they introduced that letter that he wrote in court, and they said, look, you've said that you have the arbitrary power to ban Nazis when you get up on the wrong side of the bed. Therefore, you cannot refuse us when we come to you saying we want you to ban pirates. So, and then that's an example. But then if you ban child pornography, you also have to ban the other one that tends to happen is foreign pharmacies. You can't let them operate websites. But it's pretty easy to see where it goes from there, right? Even if we're talking about laws, right? Because there are laws in other countries that say it's illegal to insult the king of Thailand. It's illegal to insult the founder of Turkey. Facebook, at various times, in its moderation policies and its army of sort of human post reviewers, actually was enforcing those. But those are rules that in most in the U.S. and Europe and many places, we would consider those laws anathema. And we wouldn't necessarily want to enforce them. You certainly think about Chinese censorship and sort of laws about promoting democracy and so on. Like, it would be a real problem to have a private company decide on its own initiative to start enforcing those laws. But again, the more we make these policies and these companies reserve to themselves the right to make these policies, the harder it becomes to say no to the next one. That's my concern with walled gardens.
So you're sort of saying it's like having a highway system, and instead of having the highway system be a place that lets people get on and drive, it's a smart highway system, and it says, well, I think you've drunk a little too much and you're underage, and I'm not sure that you should be visiting your ex at this hour of the day. Is that the kind of thing you're saying?
It is, right? So maybe we want to design a smart highway system that stops people who are trying to escape from a bank robbery. But if you do that, then why not people who are trying to escape from securities fraud, or some people who are trying to escape from, you name it, whatever cause X is, where you may have a huge constituency of people saying, we don't want this, right? Let's deny those people the ability to drive.
So this is, presumably nobody on this panel is pro-child pornography, right? Good. See, we agree on something. It sounds like there are a couple of issues that stand out. One is accountability. If you have a lot of private governance buried within systems, and you have to be able to read some of that legal language that Kathy showed us and understand what it is in order to understand what the implications are of going to a donuts registry rather than somebody else. Like that's unaccountable private power in a certain way, or Potemkinly transparent private power. But so there's that account. But then there's also a jurisdictional question. Like, presumably we all think there should be some kind of regulation of bad behavior, right? Somewhere. But is it at the ICANN level? Is it at the registry level? Is that? Do people think that those are fair questions to ask? Okay. Becky wants a word.
Well, I think they are fair questions. And first, and I'm just going to say to Kathy, like everything at ICANN, the PICS, grandfathering the PICS is all my fault.
So PICS is the private
interest commitments. No, but
public
just a
interest
joke.
commitments that were voluntary.
I am on the board of ICANN. I am now speaking entirely on my personal behalf. But I think we're conflating enormous numbers of issues here, and it is making me very nervous. So I just want to take a step back. I think that we can all agree that the things that threaten the infrastructure and cause technical harms are, I think everybody's conceded those are fair game. There's no state, when the registries, these PICs that Kathy put up there, were commitments that private companies made because they thought it would help them get their domain name. Now, I can tell you that I hope we never see anything like that, that the process by which that happened was appalling, and most registries and registrars were appalled by the process as well. It has created...
Because it was appalling, because why?
Because it was a reaction to anxiety on the part of, legitimate anxiety on the part of governments about how are consumers going to be protected in this, and a potential crackdown on the ability to apply for domain names. So a subset of registry applicants came in and made these public interest commitments that were like literally everything in the kitchen sink. They just threw everything in it. From a governance perspective, my view was that ICANN should never have agreed to those because enforcing them was a huge problem. Now, I can address this problem by outsourcing the enforcement of it, and maybe that's worked and maybe it hasn't. But the companies did make all of these contractual commitments in a bid to outcompete others. I do have a real problem, fundamental problem, with having allowed people to make those commitments in order to get a competitive advantage, that we're going to walk away from them and saying, they're not enforceable. And so when we grandfathered the existing public interest commitments into the new bylaws, it was a kick the can down the road. We've got to figure out a way to deal with this, and hopefully, Jeff, and we won't have, endless kitchen sink PICs in the next round, but who knows what will happen in the next round. But I personally do have a problem with this. I'm gonna make a promise to get a competitive advantage, and then I'm not gonna do anything about it. But the other thing is, Mitch said something about it's important that there are a lot of registries. I mean, if there are a lot of registries and they can all set their rules in different ways, then maybe it's not such a big problem, and maybe we shouldn't be so anxious about it. And then I'm just gonna, I promise I'll stop talking, Sarah. No worries. But I'm just gonna give you an example of something that I dealt with as a registry operator quite recently that had nothing to do with infrastructure or technical harms. Somebody calls and says, there's something weird going on in these domains. And I look at them, and this is a greatly simplified and actually much less flagrant violation. 100 different sites, all registered by the same person, selling every single breed of dog in the world to American consumers. The site was not based in the United States. And then there also had sites where they were shipping, offering to ship the puppies to anybody who would buy them sight unseen. There was nothing, I didn't go and buy a dog on this, so I could not tell you personally that I was ripped off and paid for shipping and a puppy. But there was no question in my mind, they were scams, and we took them down because they were ripping off consumers. So if you can tell me, I mean, I think it's critical that people be able to exercise that kind of judgment where consumer harms are involved. And I think particularly in a place where there's no state action, and the scammers can go and register in some other site if they want to, and somebody who thinks that's important speech can protect it. But I didn't think that was my job, and I wasn't comfortable with doing it. And I don't think, and I'll stand up and defend, anybody's speech rights, but not when it comes to ripping off consumers or running puppy mills for that matter.
Sarah.
Thanks. So I'm on the board of both ICANN and EFF, so I'm going to give a giant disclaimer that I'm speaking for myself. I see both sides of this issue. On one hand, I don't think it's surprising that we see contractual provisions where registries and registrars have terms of service that prohibit trademark and copyright infringement and other abuses and say they have the right to take action. So we see all sorts of third-party sites with these exact same provisions, ISPs, and in fact, under the DMCA, if you're a service provider, which is basically any website, you have to take the content down expeditiously or you could risk losing your safe harbor. So there's a liability issue at play. So I don't see the fact that it's in the contract that surprising. I also think in the bigger picture scheme, we need to recognize that we're in a different era now, like Jeff said, where there's more pressure on whether it's platforms, ISPs, and it could be registrars and registries to take a greater fiduciary duty over what's happening on their website. This is especially true for fake news, for interference with elections, threats against journalists, and there's privacy breaches, and there is a real risk and discussion that Section 230 of the Communications Decency Act, which gives immunity to publishers who publish third-party content, there's a risk that could be taken away or weakened. So I think, and we're seeing calls internationally for greater what they're calling cyber hygiene, but making sure abuse doesn't occur on your platform. And we have academics like Jonathan Zittrain and others talking about notions like information fiduciary. So I would say that there could be increased pressure on the ICANN community to think about the public interest in terms of playing a fiduciary role. So all that said, at the same time, I totally see Mitch's concern and others' concerns about the slippery slope of all of that and what EFF calls shadow regulation, because once you start doing it for one thing, it starts off as something small, it grows into something larger that's outside the scope of the law. So I do think we have to be cognizant about that as well. Thanks.
So Jeff has had many facial expressions over the last few speakers, and I think we should give him a moment.
Thanks. Sorry, I show my expressions on my face most of the time. Yeah, I just want to give an example of, it's interesting now that we're all agreeing that taking down names for malicious activity like phishing, farming, malware, and spam is something that we all accept. Because back in 2005, that was not the case. And so back in 2005, I was the chief legal person for the .biz registry. And I got notified by an organization comprised of ISPs that because of the enormous amount of spam that they saw on .biz, that they were blacklisting every single address, .biz address. So any email being sent to anyone with a .biz address was being blocked. Any email from a .biz address was being blocked. So this basically, .biz showed up on the most abused top-level domains. It killed our reputation. Our numbers started to go drastically down in terms of registrations. Legitimate companies that were using .biz or people that were using .biz were now complaining that their emails weren't going through, they weren't receiving emails. And at the time, .com, so VeriSign was on record for saying this is not anything we're going to do. This is regulation. This is a slippery slope. We are not taking any action on any kind of abusive phishing, farming, malware, spam, any of that. Go to a court, get a court order, and we'll do it. That was the prevailing view. .org was the same way. Everyone was the same way. I went out on a limb and created the first anti-abuse policy of any registry and put it into effect. That effect basically said that once we got a complaint of malware, phishing, farming, spam, we would confirm that that was going on, and so we built a lab environment to do it, and that we would let registrars know that you either have 12 hours to take the name down yourself, or we'll do it. And we were seen as pariahs in the community by everybody. We had people coming to us saying we're, shadow regulation, slippery slope. How can you do this? We got threatened by some of the major registries for saying you're making us all look bad by doing this. How could you be doing it? In that year, in 2005, 2006, we took down somewhere in the order of 32,000 domains. Guess how many complaints we got for taking down false domains or domains that weren't used? 0. In the 10 years I was at Neustar and the .biz registry, we got 0 complaints. We took down hundreds of thousands of domains. It was not an easy decision to start this in place, but it took .biz from the most abusive TLD list to one of the safest TLD lists in about a 6-month period. And you know what? We had to do it because our customers were leaving us, and rightfully so. We were not deserving of getting that business, but we turned that around. So I think you need to look at it from many angles. I am so delighted now that everyone is saying that phishing, farming, malware, it's acceptable to take those down, because that was not the case. But I'm happy about that. And I think some of these other examples may convince people that, no, look, we all know about the slippery slope. But just because it can be a slippery slope and lead to things we don't want to touch doesn't mean we should just wash our hands of it, especially as Becky has said, when we know that consumers are being harmed.
Turning to Kathy. Or do you, Mitch, I'm sorry, Mitch, Kathy, do you mind if Mitch takes it and then you have the last word? Okay. And then we're going to questions, so start thinking about that.
Right, I think this isn't, responding to Jeffrey, there is an issue here of norms and of process. And to illustrate that, I'll give another example that's far afield. And that's, do we think that the power company should take upon itself as a matter of good corporate citizenship to combat fraud by receiving complaints from people about fraud, and when they and investigate those complaints, and if they find fraud, cut off somebody's electricity? Who here thinks that's a good idea? It sounds bizarre, right? So for the record, for the folks on the internet, I didn't see a single hand here. And the reason that is that that's not how we, as a society, conceive of the electric company. We don't see that as their role. No matter the electric power is certainly used in the commission of all kinds of crimes, and frauds and harmful activities are enabled by the use of electrical power. They are in fact so the power company is in fact an indispensable component of most criminal conspiracies or fraudulent businesses, and yet we still don't think it's their role. Now, the domain name system, right? I think we certainly have that norm in .com, right? Which is partly why we don't see these sorts of activities going on in .com. These sorts of content regulation happening in .com quite as much. From what Jeff is describing, it sounds like there is at least some segment of internet users who do see some of the new GTLDs like .biz in that role. I don't know that that's a global norm, You know, I certainly don't think that's a norm among what I would call sort of everyday internet users, the person who just wants a personal blog or a website for a small business. I don't know that they're thinking, you know, that they're not lawyers, they're not getting into the fine print, you know, that comes with a domain registration, and they're not thinking, oh, well, you know, I better choose a top-level domain, you know, with, you know, who's, you know, that has an arbitration policy that I agree with. Mostly they're choosing because they want one that's catchy and that goes with the name of their business or something like that. Also, once they've chosen it right, it's really hard to change because you lose potentially all the traffic to your website if you change your address. So whatever policies that registry adopts after you have your domain name are basically out of your control. Long story short, right? The difference here is, you know, what is the norm? Do we as a community decide that, you know, not that we want, you know, that we want people combating fraud? Of course we do. And it's not that, you know, do we want people to stop abusive behavior? Of course we do. The question is, who do we want doing it? What processes do we want them to employ when they do it? And who sets those processes? And are they set by private companies with a profit motive? Are they set through a community process? Are they set through the laws of some relevant jurisdiction? And which jurisdiction is that? Right? These are the questions we're really confronted with. One other little point about on the competition point. It's true that the plethora of new domain names, and I understand there may possibly be many thousands more coming, that gives us the space for competition among policies. But that only works if people understand what they're buying. That only works if the difference between these domains is evident to that ordinary internet user, that person who just wants a personal blog or a small corporate website. Really understands what those differences are, and it also depends on there being real differences. You know, one company, Donuts, owns I think about 1 in 6 of the new top-level domains. That's you know, and they are, like Kathy said, implementing trademark enforcement policies that were considered and rejected by the ICANN community. But they are still the policy for 1/6 of the new top-level domains because one company decided they wanted them to be. That cuts against this notion of competition, and especially also that if there becomes a race to the bottom with these things, if there is the ability of registries to target constituencies and customers other than registrants and ordinary internet users. If we can say, we are the registry that just wants to please government, so we're going to act on every tip from law enforcement, whether it's been adjudicated or not, or we're the registry that just wants to please trademark holders, so we're going to, you know, confer rights that no trademark law in the world confers, but we will, to please trademark owners.
And your last point.
Once we're in that open season, again, it's hard to come back from it.
Okay, Kathy, wind this up for us before we turn to our questions and answers.
Okay, then, wow, you heard it here first. ICANN has changed in terms of what its scope and mission is. In 1999, 20 years ago, we were, the internet was a public resource, and we were managing top-level domains in the public interest. During the new GTLD program, it looks like, and it's been discussed, that registries took the base registry agreement, an agreement which, by way of background, you should know, we negotiated together. It was part of the negotiation of the rules. And it was the same registry agreement every registry was supposed to sign. It was just supposed to be tweaked a little bit. We allowed in the kitchen sink. That's what Becky told us. We allowed in the kitchen sink things completely outside the scope and mission of ICANN, things completely contradictory, including protections of intellectual property or catering to law enforcement beyond due process that had never been agreed to by the ICANN community. But then we grandfathered it as part of the transition. So ICANN, after 20 years of fighting a world that wanted us to be the content regulator, and we said, no, we regulate the infrastructure. We regulate the layers below the application layer. We don't regulate content, and you don't want us to, because we're global, because we scale, because we run the technical infrastructure. That's no longer the case, I guess. We are now content regulators. The question in Jeff's group is not throwing out these voluntary, not so public interest commitments. It's how to get ICANN to enforce them. That's what's going on in the subsequent procedures working group for the next application. I think in exchange for the transition, we got censorship. Thanks. Sorry, that's not a summary.
And turning, I wasn't asking you to summarize. I was just asking you to complete the sequence of speakers. So we're going to we're going to questions. I'm going to give the prerogative to the conference organizer. Okay, sorry, yes. And please say who you are so that the people who are watching this on a webinar can know that too.
Steve Del Bianco with NetChoice, and conversations whipsawing between reducto, absurdo, slippery slope, and conflating enforcement of promises with ICANN changing its policies. Let's try to be more practical, and I'll ask you a practical question. I think Becky quite appropriately pointed out that if an applicant made promises and got their domain because of the promises, it was only sensible that ICANN be able to be one of the parties that held them to their promises. NetChoice members make promises all the time on creating a safe platform or space, and it's understood that the FTC and other law enforcement and courts can hold them to promises. So my question would be, when it comes to these closed generics that are run by a single company, if Goodyear got .tires and decided to light up only Goodyear content and bias things like search.tires, winter.tires, and info.tires in a way that biased towards Goodyear's products. If that was completely advertised, Goodyear's logo was on the page, that would probably be okay, but what if it was a subtle bias that went on? So Kathy and I joined arms at ICANN years ago to say, wait a minute, ICANN, you need to stop this from happening. You can't let a single competitor control it. So what happened? We went to the Federal Trade Commission and said, you know, rather than prohibit it ahead of the fact, we'll just watch closely. And if there is unfair and deceptive trade practices, then the U.S. would enforce on it, so that if Goodyear did something like that with .tires, they would go that way. And that is the way that it ended up going at ICANN. There's no prohibition, right?
Yeah, there is.
Yes, there is.
For the purposes of this, competitors do run closed generics today, and they could exhibit bias, but thus far they haven't. So do you think it's appropriate to just address bias, to address unfair practices when it happened, or do you believe you need to preload a prohibition?
Thank you, and we need to get the rest of the questions, and then we will have the panelists deal with the questions. So the first question is preload it or deal with it after the fact. Okay.
Hi, this is Michael Karanikolas. So my main research specialization is actually not connected to trademark law. It's on human rights standards and how they should apply to the tech sector. So from that perspective, I'd like to suggest a distinction, because a lot of folks have been talking about Facebook. And I would argue that there is a distinction between Facebook and Twitter, which are platforms that provide a curated experience to their users, and the more infrastructural players like AT&T or Comcast or Alcatel, which is building pipelines to carry internet traffic undersea cables. And I think that there's a conceptual difference between Twitter saying we don't want to have Milo Yiannopoulos on our platform, and or saying we think that this particular Kurdish nationalist organization is a terrorist group and we don't want them there, and Comcast saying we are going to install a filtration system so that nothing that Steve Bannon or Milo Yiannopoulos says can reach any networks of ours. So I think that that difference between the platforms and the more infrastructural players is critical. And so my question to the panel is, do you think that that is a fair distinction? And if so, what side of that ledger would registries fall on?
Thank you. Infrastructure or content platform. And behind you is Andrew Renz, who's been waiting, and then Brian. I'm sorry. Oh, did you have a question?
Yeah. Christine Hay-Farley. I wanted to just note for the record that we did invite donuts to participate. donuts has been mentioned in both panels, so I just wanted to make that clear. And I wanted to invite the panel to talk about closed generics, which was implicated in the last question. We didn't really have a chance to talk about it yet. And I guess I just wanted to ask, since Becky said, I hope that we don't get kitchen sink picks in the next round. I just wasn't clear on what's being done so that we won't.
Okay, Andrew and then Brian. And let's be quick. Yeah, just go over there quickly. Did you just turn it off? This is working fine. Come here.
It's being cut off right at infrastructure. Thank you. So, I have a blog, and let's say it's hosted, and I registered with one of the generic domain names or the curated, non-curated domain names. I want to know if you're going to decide about the content of my blog, because you're going to get a complaint about it, because you will, from the Intellectual Property Association of South Africa. They don't like what I have to say. You will. So where are the rules? I need to know the rules up front. Like natural justice is, if you're going to go around deciding whether I can speak or not, I'd like to know what the rules are. And then if you've already agreed with ICANN to enforce intellectual property or some kinds of other things, then it's not clear to me that it seems to me you're a biased judge. So you're not an unbiased judge. And then do I get an appeal? So it seems that if we're going to exercise the kind of power that governments exercise, then we want to use natural justice. And then I don't see all the elements of natural justice there. They seem to be missing.
Thank you. And do you want to use this mic?
Sure. I want to say thank you to the panelists, and thank you, Sarah, for making a good point about the kind of balance that the law, at least in this country, has struck between the content hosting providers and their obligations to remove content when something is reported to them in exchange for safe harbor. And I wanted to ask the panel if you think that that is a fair balance, and if it is or isn't, how do you think that balance applies to ICANN and to registrars and to registries?
Thank you. That's it for the questions, and we're going to go run about 10 minutes over the regular time because we started 15 minutes late. Why don't we pick up closed generics quickly first, and go, Sarah.
Thank you. So I thought I would share one real-world example of an applicant who applied for a new GTLD. They applied as open. It wound up being operated as closed, and it was .bible. So they had content restrictions based on a very specific definition of the word Bible and Word of God, as that accepted by Christians. So their definition of Bible in their original policy was that you could register there if you believed Bible was the 39 Old Testament books and 27 New Testament books. And you could register a domain name consistent with that definition. Also, you had to agree to their content restrictions. There was no disparagement or blasphemy of any content that espouses or promotes a religious or secular or, quote, other worldview that is antithetical to the New Testament or non-Christian beliefs. So people who were not Christian, by de facto, were not allowed to, Judaism, Islam, Hinduism, agnostics, atheists were excluded, and even those Christians of different variations, Baha'i Faith, Jehovah's Witness, Mormon, they were also excluded. And as well as, let's not forget trademark owners. There are people who own marks like Style Bible and Fashion Bible and Girl Bible. They could not register in this space. And then on top of all of that, they had a dispute resolution policy. If you wanted to be one of the arbitrators, like you do UDRPs or other decisions, and you wanted to sign up with .bible, you had to sign an oath that you believe the Bible is the Word of God, which brings salvation to Christ, and agree to a lengthy panelist affirmation. So that, of course, goes against norms. So at the end of the day, I will say that I see their policy has changed. I don't know why, whether that was divine intervention or they saw the light, but either way, super happy that that happened. But I think this is a real world example of what happens in a closed generic space, and we need to be mindful and careful of this as this policy goes forward.
And both Kathy and Jeff have their hands up. Go Kathy, then Jeff.
Really fast. The Bible is a great example. So when you're a closed generic, the registry owns all of the second level domains. And so we agreed to allow brands to do that, not to force IBM or Sony or Ericsson to sell second level domains through the traditional registry, registrar, registrant model. But when we saw the new GTLDs unveiled and looked at their details, there were dozens of closed generics: search, cloud, blog, mobile, book, beauty. Amazon, of course, wanted .book as a closed generic. They would own all the second level domains. With Steve Del Bianco and others, we actually got ICANN to launch a discussion about this. We heard from people, hundreds of comments from across the world saying, no, this isn't good. We reversed it. There are no closed generics now, although some may be operating that way when they're not supposed to be. But it's really, really lucrative to lock up the generic word of your industry or business. And so we're hearing about it. You hear in the subsequent procedures working group about closed TLDs, not just closed generics, that anyone, there seems to be a movement from a working group largely dominated by incumbents that they can do anything they want, and that's really hard.
Okay, Jeff.
I guess I have to defend the working group. The working group didn't just willy-nilly take this issue on. In fact, the board resolution that temporarily restricted closed generics specifically said in the registration that our group was to look at the policy or our group was to determine what the policy should be. So that's what we're doing. We're taking input, deciding what the policy should be. So it's not as if it's a settled issue. It's not that easy. But I can make a lot of cases where a closed generic actually is more beneficial for end users than the generic top-level domain. Again, I used specifically the word end users, not registrants. It may not be fair to registrants, but it may be much better for end users. Give you an example, .disaster. Okay? It's a generic word, right? Pretty generic. What if the International Red Cross applied for .disaster and said, you know what, we want to control that, and we want to make sure to use it with any natural disaster for which we, the Red Cross, collect donations for, so that everyone in the world knows if you go to a Hurricane X disaster, you are actually contributing to the official disaster fund of the Red Cross. Now, let me ask you, what's more beneficial for end users? That or allowing a company like, I shouldn't say donuts because that's a bad example, allowing a company to just sell willy-nilly .disaster to anybody that wanted it for any reason whatsoever, thinking about the possibility of fraud. Think about that. So it's very easy to say a .mobile example or the .book example, but at the end of the day, who are we looking out for? Registrants? Is there a legitimate right to register any name you want? Is that a fundamental right? Or are we taking a look at what's better for the end user? And I can make a lot of cases for reasons why a closed generic could be a lot more useful and beneficial to end users than the new TLD program registrations right now. I ask, how many of you have seen domain registrations in the generic top-level domains in the wild? I probably saw a few. But if a company like Amazon had .book, and they could actually make it so that every author that sells on their platform or every musician, I guess, an audiobook, whatever, could have an official page and that end users could be certain that that's the official page. Is that better or worse than just throwing .book out there for anyone to register and no one ever using it and people just redirecting it to different places?
Okay, so I can just see that closed generics are going to eat the rest of the time. So I'm going to say apologies to the other questioners in advance, but stick around for the reception, which is on its way. And let's talk
Actually,
about
Pat,
it there. Let's
Pat, if you don't
continue.
mind, could I speak to the other questions real fast?
You want to? Okay.
To two of the
Right,
other
all right.
questioners, if I may.
I'm delighted to change. There are two people here who want to respond to other issues, and I'm delighted to honor them.
Thanks. Actually, wanted to get to Michael's question. He said that there's a spectrum of different actors who are all potential gatekeepers on the internet, from the infrastructure level to the content level. And I agree, and I would say that yes, the companies in different roles should have different responsibilities and should govern their own conduct a little bit differently. I think that's absolutely true, and that's what I was trying to get at with the power company example. We don't expect. In fact, I think most of us would reject the notion of the power company doing law enforcement or fraud enforcement or some other sort of social norm enforcement through the punishment of cutting off people's electrical power. In order to be good corporate citizens and to protect people. I think most of us would absolutely reject that. A majority of Americans reject that with respect to conduit internet service providers. We know that from the battle over net neutrality. We don't want the company that actually brings the internet into your home to have that sort of decision-making power over content. Now, where do domain name companies fall in that? The norms probably are a little bit more clouded, I think, and I think they vary between communities. But these are important questions that I don't think we're actually wrestling with. Not in that sense. That we're wrestling with them on the technical level, on the level of edits to existing ICANN policies, but that's not a forum where the public, people actually affected by this, I think are actually understanding what's at stake. And then just really quickly on this point about safe harbors, and at the risk of contradicting one of the people who decides if I get a raise, there are two laws that a lot of folks are referring to when they talk about safe harbors. One of them is Section 512 of the Digital Millennium Copyright Act, which is specifically about copyright and only applies to certain categories of internet intermediaries. I don't know that a court has ever decided whether domain registries fit into one of those categories. I believe they haven't, but somebody may correct me. The other one is called Section 230 of the Communications Decency Act, and that applies to everything but intellectual property. It applies to, it shields a broad category of intermediaries from claims of legal liability arising from things that their users do, and this is things like libel or defamation, other sorts of things that other people do. These two laws together are kind of what made today's internet possible. There is a misconception that moderating content or failing to respond to complaints, outside of this narrow category with Section 512 causes one to lose their safe harbor. That's actually not the law, especially with Section 230. There's a misconception that's being spread around the media right now. Section 230 protects internet intermediaries whether or not they moderate. Protects them from claims arising from somebody else's words.
And summing up. Is that it? Okay, great. Moving on to Becky then. And Becky, you're going to have the last comment for me.
Okay, so I find this utility metaphor, the power company, just sort of odd. Because frankly, if the power company cuts off my heat, I don't have heat. And I probably don't have a choice of where to go, and power companies are utilities. Same thing with the net neutrality, and with the Section 230, the role of registries and registrars is not, it just doesn't fit into that paradigm. They're not offering platforms for the publication of platform. They're running registries.
Well,
really.
Section 230 would apply to
Well, except that, I mean, okay. Theoretically, I don't think that I don't think that it's ever come up. You asked a question, Andrew, that I did want to answer, which is that the DMCA safe harbor isn't really, it really isn't applicable to registries and registrars, but it obviously is a place where if you are running a website and you have content that's infringing, you obviously have to, allegedly infringing, you have to receive a complaint and act on it and the like. That doesn't, I mean, it doesn't, when somebody with a copyright issue, alleged copyright infringement comes to a registry operator, there is no choice for a registry operator to say, take down that piece of infringing content. Now, as to your question about who makes the rules and how do you find out what they are, I want to say with respect to intellectual property, I find that the issue is a lot cloudier and a lot more complicated. And so to agree to your point, most registries and registrars with respect to trademark would say you do a UDRP or a uniform rapid suspension, you go through there. The copyright, we have looked at a number of the trusted notifier systems, and I have not found them to be satisfactorily useful, and there's no real due process associated with them. So I have not found a system that I like and that I think works. That is not to say, however, that I wouldn't like to have a mechanism that really did work, short of, of having to go to court to find a solution for some of the copyright infringement. But the issues that come to my desk really are the consumer fraud ones, not the, and so we are talking about something that requires a whole lot more nuance than we either have time for or have been able to tease out in this discussion. Because the issues with respect to copyright and trademark are not the same, and the issues with respect to what's legal in Thailand and what's legal in the United States are not the same, and the issues about consumer fraud are not the same. And I don't think we've gotten to those. So, I guess we just have to continue the conversation.
And what a great way to wind this up. I don't feel bad at all that we're unable to have a round of final remarks, because there's no way at this point to seal off this conversation, because these courageous people who came here today launched a conversation that really hasn't been had yet. And it's a big conversation about governance and about location of governance, about regulation and location of regulation, and whether the kinds of ways we are evolving this structure of domain names now deserves more attention and open discussion. And here I want to thank Michael, say it for me. Karanicolas, for raising this issue of transparency, because although transparency is this magic word within ICANN, most of us have no idea what's going on in any of those venues, and we don't understand what's at stake. And I want to thank WCL for launching the discussion that happened here as beginning as it was, and in the earlier panel, and I want to see whether we can begin to continue the conversation at the reception. Thank you. I have no idea how to get that thing off.
Yeah, I got it. Sorry, I should have gotten it. Well, and if people can come up and touch your wires, screw them and throw them out. Don't worry. Screw your camera. Make sure you have all the things done.
mandatory picks that are. No, they say no, they said mandatory picks, and if you want anything in these regulated ones, you're gonna have to make But it's censorship, and they put it in, and your grandfather. No, they still. Well, then I can say, how do you, in a true, wonderful, like, professional, so, well, of course, we can't do anything about it. So have a pick trick. And I talked to, I can't believe they didn't even review these. Okay, there's nothing good about this. There's nothing good
So,
about this,
but
but I
Kathy,
because
but
because I
Kathy.
know about the new, not about the new, not those guys also made promises. We're gonna theoretically hold you to those promises. But no, that's all they want. They put some crap in the agreement. Why hold them to anything? Nobody's holding them to anything anyway. Yeah, no, Jeff committee is, they wanna know what happened.
But you like that decision. It's a pig. It's a pig that came top down.
Yes, but it was given in exchange for some of the revenues and all the intellectual. So I still don't understand. Google said that they knew it was against the law.
Google did not say that. Was if we accept the concept of having pigs, then we were talking about enforcement. So it's still a big if, which is the calls that we talked about in the if part. It's unfair to tell voters that our business concludes. The question for that day was, going forward,
Hey, Jeff, saying this to Sarah, you've said it, I've heard this from a lot of folks in the industry.
Join the table.
I am under pressure from my customers and my conscience to regulate content barriers with fraud, right? I'm not paraphrasing what you said, and I've heard similar things from other folks in the industry. It seems like, there seems to be those two ways to look at it, right? One is, therefore, I will become a fraud enforcer. I will become judge, jury, and executioner of fraud. That's one way to go. The other way to go is to say, the ICANN community has decided
yeah, that doesn't work. Look, when we adopt this, we're losing customers left and right. The spam, malware, all that other stuff. And by the way, not everyone's convinced that spam is a regulation of content. Right? That's not necessarily.
No, as a matter of fact,
right?
I lost the spam law.
Exactly. But the point is, but when I was, you have to, as a registry, you have to weigh the pros and cons. And in weighing those pros and cons, I thought if I could, this was what I was saying. And I went to my guys and I said, you need to 100% be right on every decision you make when you tell me to take down the site. And only if you are, if you make any mistakes, I'm stopping. Right? And you know what? I weighed the pros and cons, and at the time, it was I'm losing business, legitimate. I'm paying consumers that have legitimate values because their emails aren't going through. I weighed it and said, you know what? Swear to it. I'm going to enforce that. I'm going to do this policy. I'm going to do it. That was the right decision.
You just added conflict. I woke up and I decided those guys are bad guys.
No, I woke up. It's I have to stop deleting things.
But you'll still see me at all the options, because I've been reacting.
And I have, I'm not going to Kobe, I don't know, I'm speaking.
And initially I was looking at
Yes, until there's actually immunity granted under the law.
But there isn't.
No, we're not. Registries and registrars, unfortunately, are not covered. No, because we never wanted to spend the money. We've never been held liable and we've never been held immune. So until you get someone that's willing to spend hundreds of millions to weighing out the pros and cons, right? So am I going to spend $500,000 to fight this, or $1 million to fight this? And at the end of the day, if I'm right, I still have lost $1 million. And if I'm wrong, shit, I've lost $1 million plus.
And it's not forward. I think it's the
But the
existing
downside is much worse.
text, and it refers, and in fact.
Right? If a
only the
court
existing
does say that we are not
are-
in a, I forgot what the DMCA and others use it. Right. If we're not that, which I don't think we are, then we're screwed, right? Nobody.
No, I mean, they are not, because
Right,
any
right. And if
text
we're
that
not
comes in a new,
adjudicated to
in
those,
a new.
then we don't,
I
you know, like.
understand the.
I work very.
That's not the way I.
Yeah, even though they're not.
Especially for the.
Well,
Right.
Oh, I mean, that's our arguments, and who knows?
Said he would stand on
And I
his
disagree
head
with the power and the
dance.
power of
That can be incorporated
uh,
into every.
Dot love, which wasn't contested, so we would have gotten it
It was
anyway.
electric and what was the other thing?
Yes, although.
Whatever it was.
Honestly,
I disagree
and
with
that's
those because I
problem
think
with the
at the end of the
fixes,
name, a
that
domain
the
name
word
is by
wasn't
definition
saying
content.
clearly enough.
Because it's a word, it is a name, it is something it's expressive, it's not something. If it didn't mean anything, nobody would care. The person got that name because it was a meaning, whereas a power,
Regulate.
it's still undifferentiated.
Because those early warnings came out about, sort of specific.
Not for website
I don't
content,
want
because
dot
the domain
Amazon,
is not the
I don't
website.
want dot
Right.
spa,
Right.
whatever.
But
I don't think
unfortunately,
the warnings that we got there
unfortunately, not everyone views it that way.
Yeah.
And when people don't view it that way, and you're faced as the legal counselor for these companies, you got to make a decision.
I mean, the donuts use this across all the fields, regardless of whether they're settling them by private auction, by high economics. I mean, most of these weren't settled, I mean, these communities.
Well, I'm not gonna argue with you about whether they were inappropriate, because they were inappropriate, but that was ICANN's fault. It was Fadi's fault.
Fadi's fault, I agree.
It was totally
Why do we
Fadi's
have to, why do we have to live and die by?
Well, I mean, I don't think that anybody's being very oppressed by them either, though.
What's that?
I mean, is somebody being oppressed by them?
Yeah, by acceptable use policies that regulate, that allow
Fadi
registries
was
to yank any
couple
domain they don't
things.
like for any reason they don't like, even if somebody.
But is that happening?
Big friends with the governments.
I mean,
And
because
so he
it
took
has its
the
own
early
authorities.
warnings
They
of the
probably are
governments.
yanking things.
But I mean, with this new venture.
Oh my
And
God.
every
Because apparently out there saying
I mean, my
that
problem
they're
with
gonna
the
be
acceptable
offering new
literally,
extra trust
when I started looking
bases.
into
For
this,
donuts, really?
hoping that
I don't know
A
what.
company that's
there was nothing
known for not having
apparently
any rules at
illegal
all?
about those sites.
So I don't know what he
Nothing
means by that,
You
but
look
I'm
at the
curious.
sites, there's nothing apparently illegal, but
I
it
have
was
no
Nine
idea.
of Russ in Russia that sold every single breed of puppy in the universe, and had a moving company who would, so it was an advanced fee scam. And it was very, like, I'm sorry, anybody who buys a puppy from Russia is an idiot, but I'm still not gonna, but the whole thing was, they were essentially selling fake dogs, and then they were selling the shipping to get them, and then you had to pay them in advance, and nobody, I assume, nobody ever got a puppy.
It's a far cry from an acceptable use policy that allows you to take down anything you want, anytime.
Every acceptable use policy for every single service in the world has the same language.
Yeah, that's the point I made.
Sure we did.
Yes,
It was
it's in .biz
.biz had it from 2001.
I think
And then VeriSign.
the truth is
has it from
VeriSign has
2005.
it. They don't take it down,
And
but
Standard
they
language.
didn't, but they do now, but they do more. But the truth is, no, I
Everything.
mean, people
Whether it's
know this.
iTunes or
It's
Yeah.
intellectual property and
anything has gone
it's
on.
a trademark infringement where somebody is passing themselves off in order to rip off consumers. That's pretty clear. I can usually spot those. And we can spot those phishing sites because they've copied somebody else, a trade, a real brand's website and whatever. We'll take those down.
Gray
The
areas, we
trade,
don't.
but the gray areas, we send them to UDRP, URS. I haven't gone to a trusted notifier on the copyright stuff,
But other
although.
people have.
Well, Donuts
Yeah,
has
Donuts
apparently,
has.
but nobody else has, because and I have asked for the packages, and the problem is the packages are not satisfactory.
I'm glad you shared that.
And I mean, sometimes they are, but those are the ones that I
But
can
Becky,
tell.
the next
But
person in your
ISPs
position at NISR might. You
ISPs
might say it's just
had-
easier to do it this way.
I mean, I think, just if you listen, just so you know that the word on the street is I'll take down anything. And I mean, so nobody is gonna take down more than I will, because when I think it's stealing, I take it down, I do.
But
So ISPs had a trusted notifier program of sorts where they got strong-armed into forwarding copyright notices from the large content owners to their customers. And it started off as that. I was always concerned about it, and then it morphed into something else. Oh, we want all your data. How many times are you sending the notices? Let's look at whether this is a repeat infringer issue, and the whole deal basically fell apart because
I don't think anybody other than, Donuts is doing it now.
And Donuts has only had like one or two cases in
yeah.
many years.
Now, so PIR, I think, got very, very close to floating a system with due process and an expert panel and stuff.
And
they
copyright,
got-
the copyright.
On the copyright stuff. And I think it was actually, well, I saw it, pulled them
Yes.
back.
Yes.
No, in part because of Phil's letter to ISOC. I mean, there was a lot
But
of
the truth is, it was a pretty good system. I mean, like, you want to protect, I mean, I assume that what you want to protect is legitimate uses, not theft, right? So, I mean, I have to start from that assumption. And that what you don't want is somebody to just say, oh, well, I got a letter from this brand, so I'm taking it down, right? That would be a very bad problem, but that never, I mean, doesn't happen at us, and we have the reputation of taking down more than anything.
I mean, you're the founders, right? 10 years from now, when there's 50,000 top-level domains, and they look back and say, I can't grandfather these terms in, this must be okay to take down anything we want, whenever we want.
Well,
The world's
but
gonna
that
be
has not been
different.
grandfathered. That has been in the terms of condition since Info and Viz and
I negotiated that
Arrow
with Louis
and
Vuitton.
whatever went into the thing.
That was me and Louis
hasn't
Vuitton in
changed.
the room.
But I can take down these things for any reason and every reason. That's always been there.
That has, I mean, .org didn't practice that, and we didn't really.
Well, no, we didn't practice it. Nobody practices it. But it's been in the,
We have
because
no
if you
acceptable use
don't.
policy.
Go down. Okay, well,
That's
so
just
an
false.
initial. Original legacy. Visions that include The registrar did not. Oh, what I'm talking about.
Most people don't. I don't know. All times. Most of the time, it's still affordable.